I also have 25B148445A.
Be honest about.
I sentenced you on May 7 of 25 on 445A. You were to pay $335. $340. If I find you did not pay and your failure to pay was not without your fault, you could be incarcerated for 90 days. Do you understand that? If I find that you did not pay and your failure to pay was not without your fault, you could be incarcerated for 90 days. Do you understand that?
Yes, sir.
On 345C, that's a civil infraction. We think you owe 227. On 345B, another civil infraction, we think you owe 213. On 345A, another civil infraction, we think you owe $225. Actually, 345C, it looks like $27. If you plead guilty or if you're found guilty of any one of those, you could be incarcerated 1 day for every $10 owed. Do you understand that?
Yes, sir.
Did you sign an advice of rights form?
Yes, sir.
Did you read it? Did you understand it?
Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that? You have the right to a lawyer. If you want one, I will be happy to provide you with one at public expense. Do you understand that? Would you like a lawyer? Enter a not guilty plea. You can go talk to the lawyer and then we'll go from there, okay?
Yes, sir. I've seen all. Sure.
Yeah.
Alexandra Wolf, 25W839121. Your name?
Alexandra Wolf.
All right. You are residing in Pennsylvania, correct?
Yes.
I can't read all this. Can you call in the prosecutor? I just can't read everything. I see that he wants to dismiss this. I just can't read anything.
Okay,
Child and both parents reside in Pennsylvania.
yes.
Child in Michigan. Mr. Urick, good morning. Your name?
William Urick on behalf of the city of Woodhaven, huh?
I'm certainly not criticizing your penmanship. Nobody writes worse than I do.
Okay,
I'm having a hard time. It says child and both parents reside in Pennsylvania. Child in Michigan on one.
she was here on a trip that was actually sanctioned by her mom and dad. So her mom and dad knew where she was, who she was going to see. There wasn't a runaway circumstance. So under those attenuated circumstances, Judge, and the fact that child's a senior in high school, the home is stable, except for the fact that the youngster's getting her wisdom teeth out today. And she's gonna turn 18
Okay.
in a month and a half.
Okay. Yeah. You said November 25. I got it. Thank you. I'm sorry.
Thank you, Judge.
Case dismissed, ma'am. Good luck to you.
Oh, thank you very much. I appreciate it.
You're welcome. Charles Laney, Charles Lester Laney, 25W839811A and 25W839812. And I also have 811B and C. And also Jennifer Marie Rainey.
I think she's on it.
Okay, this is 25W839813. Okay, Ms. Rainey, can you state your name, please? All right, your name, sir? All right, Ms. Laney, your name? I'm sorry. Rain, your name.
Jennifer Rainey.
All right, you are charged with possession of drug paraphernalia. Ma'am, I'd like to see your face when I'm talking to you, so I don't know if you can set up your tablet differently or whatever device you're on. But you're charged with possession of drug paraphernalia. Wait a minute, where are you going? Now you're sideways.
Is that better?
That's a lot better. Thank you.
Okay.
You're charged with possession of drug paraphernalia. You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer?
Yes, please.
Mr. Laney, you're charged with possession of drug paraphernalia. You also have a speeding charge, a no proof of insurance charge, and a driving on a suspended charge, and you have the right to a lawyer.
Yeah.
Would you like a lawyer?
Yes.
Yeah, I'm gonna set you both up. So we're gonna have two different lawyers, John. We're gonna have you talk to one, and then we're gonna have to have somebody else handle the other case because of a potential conflict. The two of you are co-defendants, so that's the way it's going to be, okay? So you can go out in the hall, ma'am, you can wait right there. We'll put you in a breakout room. Just be patient, don't go away. The lawyers will be with you as soon as they can, okay?
Okay.
Thank you.
Thank you.
Good morning.
Who's that right there? This is not your last name. So. That's the wind up piece. So we get part of it. All right. He actually brought the file. Okay.
Oh. How you doing?
Judge, it's nice to see you here.
Not feeling too good today. I don't know what's going on.
It's bad here in the 25th District Courthouse. There's been the whole day there. Person questioned in a tiny room here.
Yeah. I don't know what it is.
Then we had to listen to Judge Clifton on a some citizen case. So it was like watching the last news. You see.
Who's handling this for the prosecutor?
Yeah, Your Honor.
Okay, so I have,
He's here, right? Or I think maybe a dug out because they're talking about.
so. Where's Mr. Kuzmiak?
Here
Can you come up here on this, please? People against Antonio David Sobush, 25-1315.
Morning, Your Honor. Oh, Mr. Kuzman, you get put your appearance out first.
Morning, Your Honor. Thomas Gooseback here on behalf of people of the city of Wyandotte.
Okay,
So I can then insert your name, please. Antonio David Silva.
so I can't really take one file and make two. It looks like he's charged with one count of drag racing, right?
That's correct.
I don't know if they do this in Wyandotte, but we can't do that. I mean, I can't take one file and make two. You're either gonna have to call the officer, have him issue another citation.
Your Honor, we'll amend the stipulation to allow the defendant, if the court so allows, complete responsible to double parking. We would remove the other citation.
Drag racing to double parking.
For sure.
Good lawyer in there.
How fast was he going?
41.
41 or what? Seriously?
Your Honor, it was not clocked on the radar with this case. The process went from Fort and Eureka to Eureka and 12th Street.
There's no notes on the citation.
Judge,
Is that right? He was only traveling 41 and a 25? Is that what you're telling me?
It's actually 35. But
41 and 30. Why would they charge him with drag racing?
I might be able to answer that better than.
I don't do double parking here, so let's get past that. I'm not doing double parking. I've never done double parking. To me, it's not appropriate to do double parking because this.
Graphic, okay?
Well, if that's what you guys want, I'm okay with that. I can't do double parking because I don't do double parking because I don't think that's fair to the state, even though I think the state gets more than their share of money.
That's why we did.
What's that?
That's why we put the whole.
So
Why not policy? If Mr. Kuzmiak agrees to impeding traffic, we'll plead responsible to that.
do you want to change this stick form?
we can, Your Honor.
But you can't, even in, I mean, I don't know if they ever do it over there. You can't add a second file without the citation. You follow me? Without a new citation being entered. If you do, you gotta have, you follow me? Because it screws up the case count. And we've been told not to do that, okay?
We will amend this and bring it back.
Thank you.
Thank you, Judge.
Thank you. Abraham, Thomas Patrick Abraham. Too far, WA 33005B.
Good morning, Your Honor. Mr. Shepard, here on behalf of Mr. Abraham. Judge, I believe you're going to want to get Mrs. Connell here. Lisa Connell wanted to speak with her regarding.
Can you get her in here, please? Sir, your name?
Thomas Abraham. Judge, I've been made aware of what's happened. We're not going to be asking for a violation of probation here, and was prepared to stipulate to the violation.
Yes.
Let me just check one thing here. August 28th, I think there should be another show cause too, right?
Yes, Judge, I just think that there'll be a positive test on September 9th, 18th, no show on September 16th, and no show on September 30th.
Sure, your name? Tell me your name again. So, I'm sorry?
Thomas Abraham?
So he was sentenced on a disorderly person charge back on July 23. On August 6th, and your name is O'Donnell?
That's fine.
I believe, correct me if I'm wrong, I checked the box chemical testing. Was this the show cause that he pled guilty to already?
That's correct.
Correct.
Okay. And that was that he failed to refrain from consuming alcohol or drugs testing positive for a cocaine metabolite on July 29 of 25, correct?
Correct.
And then what I did is, I think, is I said defendant in treatment, have him test. I set it for sentencing today. I wrote tested plus 1 time hyphen 12 times.
You had him tested once a week.
So what did I do? Just say that? We're setting a sentence?
Yeah, you had him sentenced, wanted him testing once weekly, for testing between this time frame, so that would be 30 days of weekly testing. And you told him that he had to be clean or it was either sobriety court or jail at this point.
And what happened on those tests?
So he tested positive on September 9th, positive for cocaine metabolite, that was confirmed. Positive again on September 18th, that was a confirmed positive, again, cocaine metabolite. He was a no-show for testing on September 16th, and then he was a no-show for testing yesterday on September 30th.
All right, so do you want a hearing on any of those? Does he acknowledge guilt on all of those charges?
Your Honor.
So what are we gonna do with him? He's either gonna get into sobriety court or he's going to jail
Your
today.
Honor, we had a dialogue today and I expressed what his options were and he would like an opportunity to apply for sobriety court. So I expect the request that he be able to plead today on the violations, be referred for sobriety court, and be given a sentencing date.
You didn't prepare another show notes.
You're on. Couple minutes.
Are you gonna get off of this stuff?
I am, and honestly, that was a violation, it was the same test, I mean, I still.
Your Honor, my client, I've had a dialogue with him, indicated that the positive test between 9 and 18 were reflective of one use. I gave him clear room that it doesn't matter if it was one use or 12, that we should make that full part of our argument, but rather is discontinued use. I'm not prepared to make an argument on 1 or 2 uses, but rather a violation, stipulate and move forward.
And yes, I want to stay straight, I'm also in the guidance center.
Why didn't you show up for testing?
Pardon me?
Why didn't you show up for testing twice?
I'm just staying in Erie still. I'm trying to close on a house by the 10th of this and be back in Taylor. I'm.
And as to the September 30th mistest yesterday, he indicated he tested this morning, but I indicated to him, just like him, your homework needs to be turned in timely. Otherwise, it's a late assignment.
Look at me, Mr. Abraham.
Yeah.
Sobriety court is not for people that are going to continue to use.
Good.
I don't want to hear about how you have to you're worrying about closing on a house in Erie so you can get to Taylor.
Okay.
This isn't come if you feel like it.
I'm sure.
This is go when you're ordered to. And you're ordered to test weekly and you didn't show up. And if you're going to start out in sobriety court by saying, I live in Erie and I've got a lot. Well, you're shaking your head. That's basically what you told me, right? Why didn't you show up?
I have no excuse for you. Like I said, it's far.
Well, then I've got to reevaluate whether or not we're either going to take you. Listen to me. We have grants and we have people in our sobriety. And these people, these probation officers can only do so much work. And I'm not going to have them chasing somebody that doesn't think they have a problem or isn't prepared to deal with their problem. When people don't show up for testing, it tells me, number one, they're using. And number two, that they're just not, how do I say it? They're not equipped. They're not equipped for sobriety courts. So maybe we should just put an end to this and just send you to jail until Christmas, and then we'll be done with it.
He'd asked for an opportunity to apply to sobriety court, Judge. Obviously, I expressed to him that it's his to lose, and even if he can obtain it, Judge, in this circumstance, it's going to be a very obvious outcome if he tests positive between now and sentencing date.
I just kind of gave him a chance here. That's what my intent was, to see how he was testing in the future. He's taking this about as seriously as a decision as to what kind of toothpaste to buy. I mean, I'm dead serious.
Honestly, that's not the case, John.
What do you mean it's not the case? I honestly don't think I don't think I want to take you. You didn't take me seriously. I meant what I said, and I said what I meant. And if you're not gonna stay clean and you don't want to get yourself help, let's just end this thing. You can go to jail. You probably will be out before Christmas, and then we'll be done with it. You make it sound like this is some kind of voluntary appearance. I'm in Erie. I'm selling my house. I don't care.
Sorry.
You don't have to apologize. You were being honest with me. I think you really put this like on your list of priorities somewhere between 88 and 197. You should be ashamed of yourself. I must not have done a very good job when you were here last time, because I don't think I made it clear to you how sincere I was about the fact that I expected you to be clean. And if you weren't clean, you were either getting in drug court or you were going to go to jail. And not only were you not clean, you show up twice. This isn't baseball. Guys who hit for average 500, they get millions and millions and millions of dollars. And instead, if you hit 500, you're going to jail. I'm going to take a look. When are you here again?
Judge, I'm here on the 15th as well.
I'll adjourn this to the 15th. I'm telling you what.
Sorry, Judge, I apologize. I'm the 29th. I'm here on the 29th as well as the 22nd.
You're not here on the 15th?
No, Judge. Unfortunately, I have a bench trial out in Ann Arbor.
I don't know if I can really wait.
I'm here on the 16th. I'm on the 16th, Judge, the next day.
Let's do the 16th, okay? Because
It's a Thursday.
Lisa, let's set this for August, October 16th at 8:30. You're going to go over there and they're going to tell you what you're going to do. Okay?
Yes.
And you're to follow their bond conditions. You're going to be going to AA 3-4 times a week. You're going to be testing twice a week. You're going to be in treatment immediately. You're going to have a whole host of other things. You're going to AA, NA.
Yeah.
You have to show up for status review hearings. We just had one today. You're going to have to come every other week to a status review with me. You're going to meet with the probation department, and the off weeks, you're going to be here every single week. This is not for the weary. It's not for somebody who isn't committed. And, you know, I'm looking at this and it's like, you show no history of really caring about this. None. I mean, you didn't show up initially. This is not a joke. You're going to make me put you in jail? You're practically almost as old as I am. October 16th, 8:30, tell them sobriety court. If is DNA open today,
I believe.
you're going to test today.
That's this one.
Yeah, you said that. I'm sorry. Here, Here. Thank you.
Thank you.
Thank you.
Thanks. Okay, people against Antonio David Sobush, 251315.
But you want to bring the dad up to it or not? So he gets.
Sure.
Even though he works for the railroad, how dangerous it is to cross railroad crossings, you know. The arms aren't down, that's all.
Right.
Edward Zelenak for the defendant.
Your Honor, Thomas Goosebaker at the People of City One.
Your name?
Antonio Davis.
How old are you?
18, sir.
Your name?
John Sober.
Can I just take a quick peek at this report for a second here? Sound of tires squealing. Two above listed vehicles drive through the intersection. They appear to be accelerating quickly alongside one another.
That's what the statute requires, Judge.
Yeah, I know. Thanks for reminding me.
Oh, sorry.
I'm just reading out loud here.
Then I read the law, but I watched American Graffiti the other night, Judge, so I know all about drag racing. Which could end up in Dead Man's Curve, which is why they got a ticket, because Wyandott's concerned about safe driving in the streets.
All right, so you're gonna plead to impeding, right? Is that what you're gonna do?
Yes, yes, Your Honor.
You're not gonna do this again, right?
No, Your Honor.
I mean, you can't do this. You know, it's funny. I gotta tell you guys a funny story. When I grew up, this is true. I grew up on the south side of Churchill, which is right by the Franken Poet drain. And there was all these cars speeding. I was a young kid. This was back in the 60s. All these cars speeding up and down King Road. And my dad there on the wall, he got elected municipal judge in 65. And I mean, it was bad. You could hear him racing up and down King Road. And all of a sudden, I'm not kidding you, it stopped because they all started coming in front of him. And he made them understand with what he was doing that wasn't going to go on anymore. Anyway, I always remembered that. Like all of a sudden the car stopped. I was like, stop racing up and down King Road. All right, no more of this. You got it?
Yes, Your Honor.
Okay. All right. To the charge impeding traffic, responsible or not responsible? Fines and costs are $195, and you have to pay those at, let me just make a note here. You're gonna pay those in Wyandotte. I'm still right about that, right, Lisa? We're having paying these in Wyandotte, right?
Yes, that's correct.
So you're gonna go over to Wyandotte. Can you pay that today?
Yes.
And you kind of lectured him about this, right? I believe you. Okay, good.
Can I take file that?
Yeah, thanks, Mr. Kuzmian. You have a
And
good-
we appreciate Mr. Kuzmiak, who's the new city attorney, for coming out.
Oh, you are, you got that new?
Well, we're the prosecutors until Bill is still the city attorney, but he may be retired.
Maybe retiring. What's that?
His term, yeah, so we're prosecutors.
You just announced it on
He
YouTube.
announced it, but it's unwarranted.
That's right. They named your room after me and I refused to
So
accept.
when they gave court buildings and offices after Mr. Zelnick, we walk in hollow revere.
Judge, and just speaking of Howell Revere, it's $150. The court just texted me for. Does it matter? All right, leave it like it is.
Yeah, he's gonna have. He's
Not
gonna,
that I'm ever worried about accuracy.
Approach for a second, just.
sure.
Just nice to meet you.
Hey, you too, Mr. Zelnick. Good luck, young
I'm
man.
back later today. Thank you. Got it down.
That's funny. Kayla McWhirter, Kayla Rose McWhirter, 25W839805A and B. Your name? All right, you're charged with drive while suspended. You have the right to a lawyer. Do you want one?
Yes.
Pardon?
Yes.
Okay, you go out in the hallway, we'll set you up with an attorney. Either way, you're coming back in front of me, okay? All right, what else? Are you Wiggins, Christopher Wiggins? Christopher Jamon Wiggins, 25W839636. How you doing, Mr. Cayley? Your name?
Morning, Judge Roger Cayley, P. 4811 on behalf of Mr. Wiggins.
All right, so you're going to plead to impeding on behalf of Mr. Wiggins, right?
Correct.
And you're authorized to enter that plea?
I am.
to the charge impeding traffic, responsible or not responsible on his behalf?
Responsible, Judge.
Okay, I'll accept the plea to impeding 210 and I'll give him till October 8th, okay?
Thank you, Judge.
Original charge dismissed. Take care. Have a good day.
You too.
William Matthew Brush. 25W838383. Is William Brush here? Oh, there he is. Okay. Good morning, counsel. Your appearance?
Good morning, Your Honor. Leslie Acock on behalf of the defendant, William Brush, who sits in my office to my right. Can you please state your name for the court this morning?
William Brush.
All right, sir. So this is going to be a bench trial?
Correct, Your Honor.
All right, sir. You have the constitutional right to a jury trial. At a jury trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. If you waive your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes, Your Honor.
Do you wish to give up your right to a trial by jury?
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
And just to be clear, and you understand 6 people would have to decide that you're guilty beyond a reasonable doubt. If you go with a jury trial, if you go with a bench trial, it's just me, right?
That's understood.
All right, I'll accept the waiver. We'll set it for bench. I note that your lawyer sent in a waiver of trial by jury that was signed for her by Mr. Urick with her permission, I believe. Obviously, it says,
Correct.
and Mr. Urick signed it. So we'll go ahead and set this for a bench trial. Pretty quickly, so it's kind of getting old. Oh, wait a minute. No, it really isn't. That's right. September, October. So you want to set at the end of October, Lisa?
October 29th at 1:00.
Is that good?
20 yes, Your Honor.
October 29th at 1:00, okay?
Thank you very much.
Have a good day. We'll see you then.
See you
Thank you.
then.
Good luck, sir. Thanks.
Thank you.
Do you have another?
I have another one, Your Honor, the Andy case.
Oh, okay. John Edward Jasinski, 251318.
Mr. Crawford, the MSBC attorney, is walking in the door.
Okay.
Morning, Ron. Michael Crawford, representing the defendant.
Your Honor, Thomas Grisback, appearing on behalf of people of the city of Wyandotte.
So state your name for room.
Judge Simpson.
You're a little old for this, aren't you?
I'm a little way old for this, sir.
You were drag racing with those kids?
I was not, but that's
Under the definition.
under the definition of.
So here's mine.
It's very loud Model A Ford, sir.
All right. He's going to plead to impeding traffic, right?
Correct, Your Honor.
All right. To that charge, sir, you plead responsible or not responsible?
I do, sir.
Responsible?
Responsible.
All right, I'll accept the plea. 195, the drag race is dismissed. Let me just make a note here, okay? Drag racing is not a good one to have on your traffic record. So I just want to make sure it's clear he's pleading to impeding. 195, you can go over to Wyandotte and pay that, okay?
Sir, I appreciate you.
Have a good day.
Thank you, sir.
Take care.
You know,
See you.
yeah, you betcha.
I don't know who that is. Shut up.
You got mad.
Just double check.
Okay.
I'm sure that's fine.
Okay.
I just wanted to make sure that they're okay with it. I don't know if that's, I just work here.
Yeah, trust me, you can go to Garden City and here and
I think so. All right, Anthony Joseph Stefani, 25W701244. Okay, so is this yours, Mr. Crawford?
Yes.
Your name, sir?
Anthony Jones, Honor.
Michael Crawford.
I sentenced the defendant on March the 18th of 25. And then he came in on a probation violation. We scheduled a revocation hearing. And it looks like he pled guilty on September 17th of 25 to the violations, failure to attend a scheduled visit on April 21, failure to complete the domestic violence program, and failure to pay his fines and costs. So I set it for sentence. Is there anything? Let me get Beth in here. Get Beth in here. Is there anything you would like to say on his behalf?
Yes, Your Honor. My client he's in a really tough position as a result of this. He's not trying to excuse the underlying circumstances. But that, I mean, he's essentially unhoused at this point. He's got an address where he receives his mail, but he's in the process of.
You don't live on Oakcrest?
Yes, he's in the process of being put out, is my understanding. And, you know, he's been in and out of jail. He's got some significant health problems, which made it difficult for him to do this stuff, show up to court sometimes. He's got a job, but it's periodic work, you know, what do you say, painting brick. So it's not a lot of money. He paid what he could on the fines today, Your Honor, which is $22. That's all the money he says he has. So.
Well, let's talk about his housing. Did you own that property on Oakcrest?
No, it's my sister.
So you were staying with her? Yes?
Yeah.
If she doesn't want you there anymore. How old are you?
40.
Why don't you have steady employment?
I lost my employment because of this case when I did I did a couple months back in February. Since I got out, I found it exceptionally hard to find work. Like, for instance, the Dollar Tree across the street wouldn't hire me because I had this on the record.
You didn't just check with the Dollar Tree, did you?
Oh, no, I've tried a lot of things, but that's why I'm working where I am, paying houses and doing whatever I can to make it out. So, yeah, they had court said he took everything from me. He took my home, family, my dog. I never got any of my personal belongings back from that house.
Wait a minute, slow down. Ms. Wild's your name?
Elizabeth Prosecution, Your Honor.
Talk to me. Tell me what you're saying here.
Your Honor, he's saying his incident it's ruined his life even to this point.
Who's Kelly Jarvis? Was that a girlfriend? Yes?
Yes, sir.
So he doesn't even have adequate clothing. He was never able to get his possessions out of that house since. He's been in and out of the hospital, jail.
I
Lost his job. He's lost everything. That's where he stands before you. Yes, he pled guilty because it's true, but he has almost no means to take care of himself. The courts. He's telling the court not that he's unwilling to work. He had a job. He lost that job, and now with several jobs he's checked out. He gave his Dollar Tree as an example. They don't want to hire him now because this is on his record. Yes, he has to live with that and be responsible for it. He knows that, but he's just telling the effect.
Yeah. 2 weeks ago, I just spent 2 weeks in the hospital and in the month of September because I had a problem with my insides where they want to remove part of the rectum.
Okay, we don't need to go into all that with all due respect.
I just wanted to tell you the severity of things that are happening to me.
Well, you caused a lot of these. I mean, you had 3 drunk drivings. I'm looking at your record right now. Right?
Yes, sir.
22, 23, 24.
I lost my father. I gave him a bunch of money I shouldn't have. And
You what?
I said, I lost my father. He got passed away. And I didn't handle it correctly.
You said something about money.
After my father left, I was given some money from his passing. I took that money and turned it into an alcohol. But since then, I've straightened myself up. I did that since we've done that time in February. I have not gotten in any more trouble. I've not been drinking. I've been on the straight and narrow. I get up every day, make my bed, and get out there and try and make a dollar. And the court may not see it, but that's what I'm doing.
That's good. Where were you working? Where were you working when you lost your job because of this incident, as you stated?
At that time, I was at Motor Ramble and on Illinois next door. Worked for a gentleman, a Hoss. I can't pronounce the last name, but I was his head mechanic there. But get a bit upset when you get in trouble and can't go to work and have to hire other people. I'm gonna keep saying on the record, I did 30 days and then 30 days credit. I did
Oh, 70 days,
Not on this case.
yes. You put me in the on February 18th from this quarter. Did almost 70 days because of this case. And then I just kept going on this meeting. And when they picked me up, sir, I was sober and didn't in any trouble. I was sitting on a friend's porch and
Well,
they
you know why? Because you violated the no contact provision.
talked to him always. No, that's what I said. I couldn't do that with the attorney standing around us.
You can't do it at all. Doesn't matter if there's a lawyer, doesn't matter if there's a police officer, doesn't matter if there's an unemployed fisherman. You can't have any contact with him. That was pretty clear.
Sitting in the hallway. Sorry, sir, I'm just explaining to you what happened. I didn't go looking for her. No, I came to court that day to see you.
Did I ask you your name yet?
Yes, you did.
Thank you. Enlighten me.
I do believe if memory's gonna serve me, it actually was where he did confront her a little aggressively that day, to the point that we actually had her come and sit in the probation department. She was originally in the jury assembly room. He approached her in there. To the best of my recollection, there were no attorneys present. She actually spoke with our court officer, Will, and we actually had her sit in the probation department for her own safety that day.
You still got warrants out for your arrest? What? Let me just check one thing. Why didn't you sign up for the domestic violence program?
I was losing my way because I kept being hospitalized because of my seizure problem. I was going back and forth with my neurologist and my doctor, and they're putting me on all these medications. Next thing you know, I'm like, I'm hospitalized like every month for at least a week out of the month, you know. And when you come out of it, and when I have these seizures, I'll wake up and I won't even. I'll have memory loss. I have a lot of problems that, you know, I don't know if the court wants to hear all of them, but.
No, I don't need to hear your medical issues. That I really.
Why I didn't, you know, when you're trying to live your life and go forward, and next thing you know, you're waking up, you know, in the hospital, and if my sister was here, she could atone to this, the trauma that it's been. You know, I probably was hospitalized probably 17 times at least this year. You know, and so finally, I just got back from seeing my doctor the other day, and now we're taking me off of all these medications because it seems like it's just making things worse.
What do you think?
And like I said, when I wake up, I have memory loss. It's hard for me to get back in the groove of things, get back into where I need to be. I have to go around and ask people their first names.
He was released from custody on April 11th. I did wait 4 days. We ordered him to report directly to the courthouse. He didn't call, he didn't report, he didn't come in or communicate with probation at all. So on April 15th, I did mail him out a notice indicating for him to come in to get instructed on that April 21st date, which is count 1 in the show cause. Mr. Savani has had ample time to at least call, at least come in, talk to us so we can get him going on things like the domestic violence program, even address, you know, payment, but he's ignored the court. And so now we are essentially, about 6-7 months, going on 7 months into probation with zero effort on Mr. Stefani. I understand he might have medical, there might be living situations, but zero communication. He's been on probation with us before. He knows where we're located at. He has our contact information. That I don't have much else. Like you said, I think he still has the warrant out of 23rd District Court. I didn't run his record today. He's got a felony drunk driving. I think he has to deal with on 23rd. I'm not sure if he was able to clear that while he was in custody, but that's where we're at. He's got things to deal with and he's ignoring our court.
Your Honor, I appreciate the probation process, and it may be true But for us, the characterization isn't really fair. He's just described to you that he wakes up, doesn't know what day it is, has forgotten people's names, and he's got to figure out how to function and get going. Because that will cause a significant problem trying to find a job, whether you should be making a call. Because you're on probation before, you have new health issues. That doesn't mean that you're any better equipped now to deal with it in view of your current health circumstance because you did better in probation 6 months ago. Those are two different issues. The man can barely function if we're listening to what he's saying. And I'm sure he can produce all the documentation and medicines to show medicines have effect. They have him sleep in longer. I mean, I talked with him about this a little bit. I mean, he's obviously been a bad actor historically, but the reality is right now as it stands, he has a physical problem that affects his ability to survive, whether he was on probation or not. So I'm hoping that we can take that consideration versus interpret it as ignoring the court. He's not cognizant of where he's at some of these days. It's not because of drugs. He can tell you he's not drinking. I'm sure he can drop and be negative. The issue is serious health issues. He's talking about seizures. I mean, the court knows some of the effect of that. That have been medical professionals know how hard it is to live with these type of symptoms, especially undiagnosed, just taking them off all the medicine. Again, I'm not a doctor, but that's a big change. Suddenly you're on a bunch of medicine, suddenly you're off. You told you need surgery. He hinted at that a moment ago. You're having seizures. I don't know what to do. I don't know your position, Your Honor, but I'm just hoping that we don't take it as him simply ignoring the court.
How much is the domestic violence program again? Can you remind me?
The initial would be $100, Your Honor, and then I think he had 8-week follow-up was $20 per the follow-up.
So you're gonna have to have $260. You said $100 initial,
$100 initial, and then the
$20 a session. So you're gonna have to have $260. I mean, I feel sorry for you in a lot of ways, and then in a lot of ways, I think you've made your own bed here. You just have. I'm going to give you another chance. I want you to meet with him today. You are to be in that domestic violence program. Do you have any idea how long from the time he signs up? Remind me. Get into it.
The next one that's available is October 7th, is next week. They won't release the next one. I'm going to suspect it's going to be late November for the next one, probably just before Thanksgiving.
Could he sign up for the October 7th if he had the $100? I'm asking you.
Oh, I'm sorry, Judge. I thought you were asking if he had the money. Yes, he can sign up last minute.
You have $100?
Oh, my God.
Defendant to attend anger management program. I'm sorry, domestic violence program. Domestic violence program. The October one. I won't assess costs. We're gonna start over.
You're I'm a little bit concerned about the $1,000 fine circumstance because of his precarious financial situation. He's just asking to be violated again. I mean, he's coming up with $100 now. He's got to come up with 1,000. Is there anything that can be done to help him with that? Because money is a real issue. Now it's looking for housing on the
I
record.
placed him on probation for 15 months, so he'd have until June of 2026. So let's see.
I have on September, Judge. Is that it? That's my
What did I say? March?
15 months? Oh,
15 months.
Yeah, I think I calculated him at 18, Your Honor. I'm sorry, 15.
That's okay.
Yeah.
So he's going to be on probation until June of 26, June the 18th to be specific. He's to pay $150 per month beginning November 1st. With all money due by May 15 of 26. Okay. And I'll keep you on probation. I'm not going to do anything else. But you kind of got to grow up. I mean, I hate to say that to a guy who's 47 or 8 years old, but you got to grow up. Good luck. Thank you. She'll meet with you today. Thank you.
Your Honor.
Yeah, thank you, Judge.
Holiday? Jasmine Marie Holiday, 24W8342440. I'm sorry, did you meet with your name?
Jasmine Holiday.
Did you meet with the prosecutor?
They just said they're here to talk to the lawyer.
Okay. Well, let's call in Mr. Urick. How long you been here?
Not too long, probably 30 minutes.
Okay. Call in Mr. Urick, will you, Tabitha? I'm gonna send him back to you. I got it. So you're compliant. This is a review hearing date. It's just basically for him to move to dismiss.
What, David?
Hey, Mr. Urick, can you come in 1 second, please?
Of course you are.
Thank you. So it's just a review hearing date. It looks like you're compliant, so he's gonna move to dismiss. I'm gonna try to expedite this for you. We're gonna hand that file to him, and then he's gonna call you in momentarily, and he'll talk to you, and he'll move to dismiss the case. Then you have to come back in here, okay? All right, it shouldn't be long. Mr. Urick, your name again, sir?
William Garrett, on behalf of the people of the city of Woodhaven.
So this young lady's been waiting around. They sent her in the courtroom. So I
think we were searching for the file, Judge. I apologize.
That's okay. So you can move to dismiss, it looks like. It looks like she's done everything. So I just wanted to expedite it for her a little bit. Okay?
See for just a second.
Yeah.
Thank you,
Thanks.
Judge.
Thanks a lot. What's your name, sir?
Ruth.
Bruce what?
Bruce Laguado.
I'm sorry?
Bruce Laguado.
Okay. Do we have him on the docket?
You not speak English, sir.
I see. Okay. What language do you speak?
Bye.
Let me see your paperwork. Come on up here a second. Come on up through here. And you can walk right in through here. Oops. Let me see that, John. His paperwork.
Here, you take this.
No, I just want to.
This is for this.
I just want to.
So,
He doesn't speak English. Oh. Do we have his file, Toscano? Bruce Toscano?
I don't even know who that is, Judge. I just.
Bruce Toscano.
Okay, I gotta look for
The 9:45.
it. I can look for it.
I know. I don't know.
Okay. I'm gonna send him down, Lisa, and we're gonna get him a Spanish interpreter, okay?
I already have an interpreter.
Oh, we have one for him today?
Yeah, there's a note here.
On the file.
Oh, okay. Okay, so we'll set him up with the interpreter. Thanks. I didn't remember him being in front of me.
Should be with me, so I don't know if they're good.
Okay, good enough. The fraud sentencing. Was it Shaw? What's his name?
What was it?
I'm just wondering what the defendant's name is on that fraud case. I read it this morning. Was it Shaw?
Thank you.
Probation.
There is.
Okay, what do you want, John?
Well, actually, I need to be appointed representative because this is an initial. I'm not appointed yet, but, and then if I do get appointed, I was.
Any objections? It shall be done. Mr. West will be appointed to represent you.
Then I need about 6 weeks on the announcement.
4 weeks, we will set it for an announcement for 4 weeks. Please get a resetting. And we're gonna just test.
Okay.
Before she leaves. Have a seat right over there.
I can get that in, just head over there.
Oh, Reagan?
Give me some more time.
Is Reagan here?
She's there.
Not sure.
She believes she's outside.
Oh, okay. Is Timothy Fernie here?
It's not on the house.
Okay, you have a lawyer?
I'm sorry.
Or you have a lawyer? Are you getting one?
Yes.
Who is going to be, do you know?
I don't know right off.
Okay, you were charged with the third-degree felony of operating a motor vehicle in a public place while intoxicated. And paragraphs 1 and 2 provide because you have 2 prior DWIs or more. It looks like I'm looking at 3, but this, anytime you are arrested and charged with a DWI operating a motor vehicle in a public place while intoxicated, it's a felony, third-degree felony. However, you've got this prior conviction in 2018 out of Orange County, which, if all of this is true, now you're looking at a second-degree felony punishment, up to 20 years in prison. That's how serious this is. I'd run like the wind to get a lawyer. Yeah. So how much time do you need? I'm going to give you the 3 weeks. When you do that, if you hire somebody, make sure you give them this resetting so that they know when you have to be back here. Okay. What was the result?
It was actually positive for GHB, which is gamma hydroxybutyric acid. Basically, it can cause extreme drowsiness. And that's what was detected.
Kind of like what y'all exhibit here.
That's correct, Your Honor.
Yeah. I'm just kidding. You know what they're talking about? What is it called on the?
Gamma hydroxybutyric acid.
No.
GHB.
What is the street name for that? You don't know? You can't just buy it at a store. We test for that?
I can check. I can check it.
Okay. Okay.
No. Sorry.
It's Timothy Barney.
Yeah. So 3 weeks, get a resetting and just have a seat in the queue. Thank you.
Just see as well. Yes.
And Your Honor, we would ask just for a drug patch to be ordered just as a condition of the bond, or if it's not already.
We need favor.
Yes, sir.
Ashley Arredondo. Ashley Arredondo. That's you.
Yes, sir.
That's the only.
Okay, you're charged with the second-degree felony of burglary of a habitation, which carries with it up to 20 years in prison. It's obviously serious. What are we going to do about getting a lawyer?
I need court appointment.
Why?
I don't have the funds to get an attorney.
Why not?
I just.
Well, I've been working since the day I turned 16.
Yes, sir.
Okay, I just, it's hard for me
I
to
mean, two months ago and spent $10,000 doing it.
say that again.
I just recently got a divorce and spent $10,000 and don't have the money for an attorney.
But you're not employed?
Currently, I'm laid off.
Well, what did you do as, for employment until you were laid
I'm
off?
a construction buyer. Purchasing.
Okay, here's what, we need to do is you need to give her one of those affidavits of indigency. You have to fill that out. It's done, sign it in front of her. I will review it and then we'll do the next step.
You already saw the piece of thank you, Judge.
We'll take it one step at a time.
Thank you, Judge.
Okay, you were Benjamin Linder.
Yes, sir.
In 25. CR 527, you were charged with the state jail felony with credit card abuse, which carries with it up to 2 years in the state jail.
Yes, sir.
Today,
Judge, I need a 4-week resetting.
you do.
I do
Or,
go through the discovery and review the offer with him.
okay. Get a resetting, sir. And Brittany Newcost.
Judge, I was informed that she hired an attorney.
She has, and there is a plea on your tablet to take care of that matter today. Judge.
Who is Ralph Martinez?
Yes, sir.
Where are they? We call into the hall for Brittany Newcost. Are you
I did actually.
Brittany Newcost?
He doesn't have a date on it now.
No answer. I asked the bailiff. Call into the hall for Brittany Newcost. Was he here earlier?
He is.
Oh, okay. They just, that's, I'm sure.
Yeah. People know.
Who's here with Brittany Newcost?
Mr. Martin.
Okay.
Did you see the fingerprint in front of me?
Yes, then. Ready? Go in front of this lady, please. Thank you. Sign some papers here.
Please raise your right hand and have you swear or affirm that the people who I'm going to take some cash.
Thank you, sir. Yes, sir.
Close it flat. Speak it up in your hands.
We are making a joint recommendation as to the time of supervision, Jeff. I've explained to Mr. Martinez, you always make that decision, but
Kind of like a partnership.
yes, sir. With these facts and circumstances and her record, I feel like it's appropriate.
All right.
And we now call Brittany Newcost in cause number 969. Does the defendant who is here with her attorney, Mr. Martinez,
Yes, sir.
waive a formal reading of the indictment and arraignment can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 5th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of tampering or fabricating physical evidence, intentionally or knowingly destroying or concealed a record, namely electronic messages and phone records. Do you understand what you're charged with here? Is that yes?
Yes.
A third-degree felony, if convicted, means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that? An agreement has been reached where you would be pleading guilty. Hard work in these darn things, isn't it?
It is, but it's better than Harris
We're
County.
getting new ones anytime, but it is just
I'll take those are the ones in Harris County.
really, they're bad.
Oh, it's very complicated. This is very simplified.
They're still.
You hear that, Judge? We got something up on Harris
They're still using slabs of rocks, aren't they? And they're etching on those.
Yeah, you gotta put 50 and then 40. It's very complicated. This is very good the way I'll do it.
Okay.
It's user friendly is what I understand. It is. Even check impaired.
Well,
there's hope
now
for
we
us,
know
Judge.
what the cavemen had to go through. Same kind of thing we're doing here.
You're doing pretty good too.
All right. The agreement is she would be pleading guilty, not found guilty, but placed on deferred or unadjudicated probation, which the party, what do the parties want on the time?
5 years.
5 years.
Yes, sir.
It can be up to 10 years. It's the court's discretion, but the parties are requesting 5.
That's correct.
And $500, and there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that the plan? Yes. Anyone at all? Everyone? Yeah.
Yes, sir, that's
Okay. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? I believe it's October 1. Are you pleading guilty voluntarily and because you are guilty? Yes, soft voice. Show you what's marked as State's Exhibit 1. Sure. Did you sign that document? Did you understand it? Discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence.
No objection, John.
Without objection, it's submitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
Picked up a new theft offense, also a new falsification charge in Kentucky that you cut off your monitor, and you admitted to the use of meth, and you have not paid your restitution. You have the right to be represented by a lawyer in these proceedings. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
I'd like to get it all done over today.
All right, I think the recommendation is that you serve a term of local incarceration and be done with this. That seems like a decent resolution to the case. But Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by a lawyer.
Here. Yes, ma'am.
I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated the terms of probation?
I admit it.
Based upon your admission, I find you violated the terms of supervision. Mr. View, anything from the state?
Nothing additional, Judge. Thank you.
Officer Cal, anything from probation?
Nothing additional.
We have 70 days of jail time credit, right?
That's correct.
What do you want to tell me, Ms. Payne?
I was just at a bad time in my life. I mean, it really was. It was just bad. I made the wrong decision. But I just didn't know what else to do. I just didn't know what else to do. But I've been drug free for over 2 years. Access helped me a lot, and then I did the rest of it on my own. But I didn't. And I went to Kentucky. My oldest grandson had graduated, and he's epileptic. He has a brain injury, and it was, he struggled for years to graduate, and I just couldn't miss it.
All right, court's going to impose 120 days in jail, give you credit for the 70 that you have already done. Technically, you are on community control for the remainder of these days, 50 days in jail. So if you get caught with drugs, get in a fight, something like that, I could still send you to prison for up to the maximum penalty. But when you get out, you're done with us.
Thank you.
Good luck to you, Ms. Payne. Next is the case of the state of Ohio versus Brandy Brown. For 21 CR 38009, present before the court is Ms. Brown, right?
Yes, sir.
We have Mr. View from the prosecutor's office and Officer Kell from probation. We're here today, Ms. Brown, because I received a report that alleges you have violated the terms of your supervision in that you did not complete the STAR program. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer?
No, is there any way I can just get mine taken care of today too?
Sure. Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney.
Well, I stayed there for 10 days, talked to the service provider. She said that I have medical problems that need taken care of, but they can't take care of them. They don't take insurance of any kind. I don't have money. Even the nurse, I have a cyst that needs to be lanced, and her and my probation officer told me to ask you about a furlough, because they said they can't do anything about it either, that I would have to go take care of it myself. But
Okay, that waiver tells me in writing that you don't want to be represented by a lawyer. Do you admit or do you deny that you violated the terms of your probation?
no, by law, I violated.
All right, based upon your admission, I find you have violated the terms of supervision. Mr. View, anything from the state?
No, Your Honor.
Officer Kell? We have 123 days of jail time credit. Sort of in the same position that we were about a month ago. Additional time in local jail, I could send you to prison for 9 months, or, well, we were going to try the STAR thing, but that didn't work. So I'll give you an additional 180 days in jail, or I'll send you to prison for 9 months, whichever you want to do, doesn't matter to me.
Okay, so if I do the 180 days in jail like that, I still come out on probation, right?
Nope, you all done with this either way.
But if I do prison, I still be all done with it also?
I mean, if you go to prison, the Department of Rehabilitation and Corrections could put you on post-release control. I don't think they would, but that's up to them.
Yeah, because I've never been to prison. Well, it's just I was trying to figure out, because people keep telling me if I go to prison that I do end up doing less time.
That's usually the case.
Yeah, I guess that's what I'll go with then.
All right, court finds you have violated the terms of your supervision. I find that it is not a technical violation. I'm going to sentence you to 9 months in prison. This includes an optional period of post-release control of up to 2 years. That means if they do put you on that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, automatically consecutive to the sentence that you would receive for that new felony. And I'm going to give you credit for the 123 days that you have already done.
Can I ask a question?
Sure.
So what do I need to do? Because medical, like I said, they told me there's nothing they can do about my cyst and stuff, and then I need to put in for a furlough, and that's what my probation officer said I'd be able to ask you about it today. I don't what do I need to do?
They're going to ride you out to prison probably within the next couple of days.
Right.
I can't furlough you from prison. I don't have that authority.
Okay, so I just need to take care of it when I get there, because they can't take care of it at prison either. So, all right.
Okay. All right.
you.
Good luck to you, Ms.
Have a great
Brown.
day.
Next is the case of the state of Ohio versus Anthony Burdett. ER 42278. Present before the court is Mr. Burdett, represented by Ms. Shy. We have Mr. Harris from the prosecutor's office, Officer Niemeyer from probation. We are here today for a hearing on the issue of diversion. It is my understanding that the parties have agreed that Mr. Burdett is going to go into the prosecutor's diversion program. The conditions of that is that he is going to pay $1,000 in restitution. He is going to turn over, or has already turned over, the cards in dispute. He's going to complete 100 hours of community service in the corrective thinking program. Is that all accurately stated?
Yes, Your Honor.
Yes, Your Honor.
So, Mr. Burdett, here's the thing about diversion. It's not my program. I don't have anything to do with it, even though technically my people supervise your progress on it. It is Mr. Harris's program, not mine. So that means if you go into this program and you don't successfully complete it, then I don't have anything to say about that. All he's going to do is send me a notification that says Mr. Burdett did not successfully complete his probation. And if in fact, diversion, if you didn't do those things, I don't determine whether you should stay in the program, continue in the program. I just revoke the diversion and go forward with sentence. You understand that?
Yes, Your Honor.
How old are you?
I'm 22.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Are you taking any medications?
No, Your Honor.
Are you a United States citizen?
Yes.
Other than what we've just talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Your Honor.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, Your Honor.
Did you review this with Ms. Shy before you signed it?
Yes, Your Honor.
Are you satisfied with the representation that you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of theft. This is a 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. If you don't successfully complete the diversion, there's a presumption that I would not send you to prison. But if I did have to send you to prison, the maximum penalty would also include an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the diversion program. Is that what you want to do?
Yes, Your Honor.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about November 15th of 2024, Anthony Burdett took sports cards from Daniel Carnell without his authorization. This all occurred in the city of Lebanon, Warren County, Ohio. The cards were valued in excess of $1,000.
Anything on those facts, Ms. Shy?
No, thank you, Your Honor.
Mr. Burdett, did you hear those facts?
Yes, Your Honor.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes, Your Honor.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think that it has been made in a knowing, voluntary, and intelligent fashion only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I am going to place this in diversion, so I'm going to stay all of these proceedings pending your completion of that diversion program, which includes the restitution, community service, corrective thinking course, and whatever other standard rules that they have for you. Any questions? All right. Good luck to you, Mr. Burdett.
Thank you.
Thank you, Your Honor.
This is the plea form. This is the Harris form, which you may or may not file.
I will follow this agreement, Judge, and find you are mentally competent to enter your guilty plea. You are doing this freely and voluntarily. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting your guilty plea to find you guilty from State's Exhibit 1, I'm going to defer any finding of guilt instead and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, normal and customary for this type of offense, and a probation officer will go over this with you here in a moment. Also, you must pay a fine of $500. And is there anything else we needed to cross T's on that I didn't?
No.
You do well. You do well. We shorten probations to a third as a reward.
You're saying that you do well in a year and a half more than you do. 20 months to be.
Actually, it's about a year and 2/3, but he's close.
You're a defensive end, so click on that.
18 months, I think, is what we figured it was. Or 20 months. Yes, 12. Over 5, okay, 60. So 60 is 20 months. It's 20 months.
And Judge, she's trying to be a nurse and she cooperated fully with the investigation after it was disclosed that she did. Brought her daughter in, she discussed everything. He explained that, admitted everything. He wants to be a nurse and it's a great opportunity.
Why?
Why?
Why do you want to be a nurse? Oh, you are a nurse.
She wants to remain.
Why did you choose that profession?
Helping people.
Good for you. There's a old great saying that I am third. Our creator is first, others are second, I am third. And that is a very selfless rule of life that makes people highly successful and beloved.
We
So
should
good for you.
price how people will pay you back when you're good to you. They will always come through at the end when you're.
Well, it's special because not everybody's like that, unfortunately. We get too much of that here where people think of themselves first.
All the young guys I helped and I'm making it there, but you know.
Those young guys are kind of old now.
Yeah, they are. They're making it.
Thank God you and I though are going backwards in time.
Good.
We're
Well, the good thing about being over almost through it. You can relax, you can retire.
I don't know what's in. Where we're headed here. It's wherever it is. It's going to be a good place. All right, please see the probation officer. And
Thank you, Your Honor. It's
thank you,
an honor going to you.
Mr. Martinez. You do me the honor, sir. Thank you very much. Reagan, do you have anything else on this one that we need to deal with? Okay. What did we do? We've got a couple of people in the queue, and is anybody, did we get anybody? They're working. Let me know what happens to them. We're going to be safe and sound. Okay, we've got some resettings here on this 9:30 docket, so we jump over to Hector Alvarez. Hector Alvarez is called 25 CR 311.
Sorry, did we do Javante Bailey on the initial docket?
Is Javante Bailey here?
No, this is.
No. Wasn't he in the?
No, he's.
No, that's you? Are you Javante Bailey? Come on up. I need those other.
Yeah.
Come on up. You're charged with the state jail felony of evading arrest or detention. And it becomes a state jail felony because it looks like you've previously been convicted of that. So every time you do this, it's a felony, carrying with it up to 20 years in prison. What are you doing about getting an attorney? Look, I'm a taxpayer. Taxpayers don't like paying for your problems. When I make a mistake, I got to pay for it. Well, that's what we all do. That's responsibility, maturity. Well, why should the taxpayers didn't make this mistake? You do, and that's what you do. When you spill the milk, you clean it up, right? And then all is well. Are you working somewhere? Why not? You look healthy. Are you able to work? What kind of work do you do? Good Lord, they're building. Why don't you do me a favor? Get on Interstate 10 and do something to help us. That's a mess.
I gotta get my delay.
That's a mess. That we need you out there working. What kind of construction is it? Roadway or house?
Third word, concrete.
When was the last time you were employed? Sir?
Beginning of the year.
The beginning of the year. Are you trying to? I mean, they're always looking for people. Are you trying or not?
I was coming to job. I lost my idea. I gotta get that.
When did you do that? Sir?
About a week or two ago.
What are you doing about that? You gotta, one step before the other, right? Yeah, let them fill out that indigent form. Sit over there in the jury box. When you're through, let us know. Then you'll swear in front of that lady and then I'll make a decision on where you head on this. But, you know, you got to be independent. You got to get a job, pay your way and fix your mistakes. That's responsibility. Back to Hector Alvarez.
Full staff judge. Huh?
Well, I don't need a
Yeah.
bunch of resettings, so.
Here's half.
Hector Alvarez again, 25 CR 311, no answer. I asked the bailiff to call into the hall for Hector. Hector Alvarez. Oh. Come on up. Who are all of you?
Judge, I'm returning. You may need to interpret for me.
The bailiff's quieting the crowd. Okay, you are representing him?
Yeah.
Please state your name for the record.
Lynette Martinez,
And where are you practicing?
Houston.
In Houston? Okay, you're a licensed attorney. Oh, okay. Are you going to represent him on this matter?
Yeah.
Oh, good. Lynette Lynn Aguirre.
Yeah.
Okay.
Aguilar
Oh,
Martinez.
good. All right. Good. Welcome.
Thank you.
And you speak fluent Spanish,
I do.
and he speaks only Spanish?
Yeah.
Is he a citizen of the United States?
No, he's temporary resident.
Okay. Are you familiar with what he's charged with?
Yeah.
Okay. There was an indictment for the record filed and handed up by the grand jury in March of this year, charging the defendant with a third-degree felony of assault on a public servant. The public servant being, it looks like a nurse in Portage Baptist Behavioral Center. All right. What's our plan? What's our plan today?
We were trying to negotiate with Plea done, but they're in the reach. I think we're not set the trial.
Okay, yes. All right. So is that what you want to do on his behalf? All right, then that's what we do. Just had a very serious case of a similar matter where the jury, the decision was pretty severe, but we'll set it for trial. And we'll get with you on a trial setting as soon as we can do this. The second largest county with the 16th highest crime rate, so we're working as fast as we can. And I'm at 600 jury trials, and crime is not stopping. I'm not deterring anything by the hard work, but we're going to keep fighting the good fight. Just get a resetting for trial, okay? Thank you. Yes. I have Brandon Mingo. Brandon Mingo, 25 CR 18. Come forward. Your attorney is Mr. Brewer?
Yes.
Is that right? Where is he?
No,
is he here?
She's not here. I was
Oh, it's a female?
Yeah, I was waiting. I said I didn't see her yet. I didn't see her yet, too.
Okay, just stand by, close by. You can wait outside if you want. If she gets here, let her know we're waiting, okay? Okay, but don't leave the building. Okay. Christopher Broughton. Giles? Christopher Broughton, please.
I give it.
Listen, what are we doing today? What's our master? Let's see. Says announcement.
Yes, Sean, I was gonna ask for a reset today.
How much time?
I don't need long, but 30 minutes.
About 4 weeks.
That's perfect.
Just testing. Is good, is that gonna be good?
Yeah.
Okay, okay.
Yes, yes, bond conditions, that's, I think too strictly done from working here. What will you be looking at? These buildings.
Well, I wrote something here.
Our projects.
Okay. I wrote here, I thought that's got to everybody. Need travel locations and dates of travel, must have GPS. That's what I wrote here back in August.
So, yes, sir. So you'll be.
But the locations and the dates just need to be made known to the bondsman so that they know.
Okay.
So if something bad happens, somebody is accountable, of where he was. And
The information is not in the truth, right?
I think that should take care of it.
That's the other go-to like
I
that.
wrote all those on this. Okay. So you want a copy of this?
No, I have a copy.
Oh,
Yes, sir.
of what I wrote.
Yes, sir.
You got one.
Great secretary, please.
Oh,
So continue.
who's that?
One of the,
Oh,
one of the
oh.
great ones that you.
Yeah. Thank you. All right, get a resetting and follow his advice. John's a very smart man.
Try it. Thank you.
We do.
Reset 4 weeks.
Yeah. Yeah, just come over here, Mr. Right.
Yeah.
Somebody get up to finish time on the spot to the drug test. So my client will be on the fence, so that's that one, still not here.
Well, Miss Towner, come on up. I don't need it right back. He tested positive for amphetamines and meth. Your bond's revoked. Yeah, but it's not even close. Your bond's revoked. Boy, I wish I had $1 ever heard that. You're in trouble again. You were in trouble when you got indicted, and you're up to the same bad habit. We're going to work on this by putting you in jail where you can't get your meds. That's what we're going to do. Sorry. You have a drug patch now, don't you?
Just have a
No.
I know, can trouble, sir, please.
I'm sorry. Methamphetamine is a serious felony offense. Possession.
I know.
You've got one now. You have one here.
I know how
The
serious
grand
it
jury can indict you again for a second one. How many do you need before you decide to do the right
No,
thing?
sir,
Quit whining. That's what it is.
Please,
I
gosh.
know. Your bond is revoked. You're taken into custody. Sorry. Thank you. That's the only way we can deal with methamphetamine abuse.
Should we hold her to no more?
Yeah, it's a no bond. Come here, John. And what's with you, sir?
I was seeing this.
No, that'd be the last free world water you drank on my watch. Just work it out with the bailiff, okay? Thank you. Stand by. dollars can be assessed. Do you? 9, is that yours?
Judge, it's been re-indicted. There's a other case on the docket.
Okay, without objection, I presume that case is dismissed.
Yes. Okay, you can go right on front. Place it right here. You get everyone now? Same one? Place it right here.
I'll try it.
There you go. You go to the entire time.
You are Richard Joseph.
Yes.
With Ms. Minaldi, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about May 5th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Listen, is that right? Yeah. Do you understand what you're charged with here?
Yes.
A second-degree felony carries with it, if convicted, no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
I don't have anything here in my queue. What's the agreement? What's
It
the
was
agreement?
deferred, Your Honor, and it was recommended 7 years deferred on it, but
No fun.
Okay, and apparently an agreement's been reached where you would be pleading guilty, not found guilty, but placed on deferred or unadjudicated probation. And I can place you, it's discretion of the court, I can place you on probation up to 10 years in length. And there would be terms and conditions of probation, which are normal and customary for this. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence without objection admitted. And this states, ma'am, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived? I'm going to follow this agreement. And I'm going to find you are pleading guilty voluntarily. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 that's admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on deferred or unadjudicated probation. You won't be found guilty so long as you follow the terms and conditions of probation. And we'll do that for a period of 7 years. And there is no fine here. Make sure you follow these terms. If you fail, your probation could be revoked. You could then be found guilty by the court and then sentenced up to 20 years in prison. That's nightmarish to think about. So a lot riding on you doing the right thing. Ironically, these terms and conditions of probation, for the most part, are the requirements all of us in this room have to follow, whether we're on a probation or not. It's follow the rules.
Yes.
Sometimes I see people go, "Oh, what? Probation? Oh, no." But it's just like, don't hurt people, live honestly, harm no one, respect each other, the kinds of things you do, you're supposed to do, whether you're on probation or not. The recipe for good life. Okay, please see the probation officer. Thank you. Okay, I've got Mr. Fernie. Do you have a turn?
I'm getting one.
You said on the initial.
I also had the, seems to possibly getting us drug patch.
I don't have to tell you what this says. You're intimately familiar with what you got in you. You got everything.
But
You got everything.
doing medications.
So
I'm just saying.
methamphetamine, they're giving you meth, are they?
No.
You got amphetamine, methamphetamine, tetrahydrocannabinol, marijuana in your system. And MDMA, ecstasy, and then benzodiazepines. Maybe benzo that might have been given to you, but the others aren't.
The benzo and the Adderall, but started off still saying, I've been doing great. And
You didn't do great here.
No.
You're free falling.
Yes, sir. I just, if I can have the opportunity to get that patch.
That's not the way it's going to work. What's his bond? Who's your attorney on this?
He doesn't have an attorney.
You're gonna have to do it from jail because your bond is revoked and you're gonna go to jail.
So if I can get that patch.
5 controlled substances are in your system. You are free falling. You need to fix that before you hit the ground and splat. You know what I mean? You can't continue to live like this without severe problems.
Judge Stevens, if you give me the opportunity, just, I'll put this patch on, I promise you,
You're going to jail. You have to face it. You're going to go to jail. Your bond is revoked on the court's warrant. That's just the way it is. We're going to dry you out. I wish I had a penny for every time people begged to be released, that you'll never see me again. And I'm going to change my drug addiction right now. And it doesn't work that way. It doesn't. That's not realistic.
Well,
actually, I am doing you a big favor. You have a problem, and I don't know how long it's been, but it's far too long. Once you get the problem, it's too long. But this is not something that you get with 5 controlled substances in your system overnight. This is built up, and it's going to take a little bit of stress and time to fix it. But we're going to try. Okay. What's his bond, please?
It's $5,000.
What are you saying? Did you say 55? 5,000. Okay. Your bond is revoked. There is no bond right now. Do you have income? You're about to go to jail. Do you have an income? Are you able to hire a lawyer right now?
If I'm able to go out there and work.
If you're able to. Okay, here's what I'm going to do is get you to fill out one of these indigent forms so we can get you some legal assistance immediately. They're going to talk to you in a few minutes. Fill that out right over there.
We're taking custody first.
Yeah. Okay. Brent, I'm going to ask you to help this man. Okay. And his name is Timothy Fernie. And where's his file?
Is it that one right there? Right there. No. Look, right there. Yeah.
Okay. He's charged with driving while intoxicated, 3rd. And he's got a prior illegal possession conviction in 18. So yeah, it's a 2nd degree. And here's the sum total of THC, meth, amphetamines, benzodiazepines, ecstasy. The breath test came back. Is that on the breath test? Was it 0, 0?
Yes. Okay,
because I couldn't tell if that middle 0 was a 6 but it's a 0. Okay. Dismiss it. Hey, Brent.
I know. I don't have to say.
Do you know when she emailed it? A couple of weeks ago, I'm not sure. Our own, so that we can initiate investigative efforts on our end, and then after that, a 4 to 5 week resetting to see what those efforts come up with.
A motion on item calendar.
Sorry, I'm having her investigated too. You happen to have a copy of it by any chance?
Do you know, Randy emailed it.
Since it's a motion between you two, I don't. Oh, you don't send copies to the staff? Oh, because it was, you're keeping them out of the loop intentionally because, you know.
I know about it. I just don't know what they're gonna find out about. I don't have to say.
Do you know when she emailed it? A couple of weeks ago, I'm not sure. A couple of weeks ago. Okay, got it. She's gonna look for it in her email.
Meanwhile, can you?
Looks like August 21st, and then it was resent September 24th.
Oh, gosh.
Yeah.
That was sent twice. We still don't have it. That's not good. Can you? Right now, we're gonna have to reset it for how?
4 weeks.
4 weeks, please. We're gonna look for it, but if you happen to resend it and alert us so that we can make sure we get
I'll
it.
be here all day,
And I
Judge,
can-
so I'm happy to.
Then I can sign. Okay, all right, they reset it. That was Ryan.
Yes, that was Mr. Highlighted it, please.
I have Jesse Pond or Fan.
Here, Judge.
Here he comes. He's charged with theft of property, sneaks up on.
This was one of the stock.
Good, hello. Whoa, mama. Whoa. Whoa. I'm gonna ask you, how many theft convictions do you have? 10. What does it say when you don't know for sure? What does that say? I know how many I have, but so does it say something if you're just guessing?
Got it.
You're not certain. Because you're wrong in your numbers.
No, just going up,
12 that I know of. 12 theft convictions and at least.
yeah. I was doing,
Wow. Six, no, it was in my court. Just look at how many money. At least 6 of these are felonies. Or out of felony district courts. At least half of them. It's time you quit. Stealing.
you know, I don't,
Begin to live honestly.
I don't do that
How
anymore.
much you asking on this?
I'm talking about my dad.
This was Miss Staub's case. I've been in.
How much, what are you asking on this motion for?
Oh, this is for Mr. McCowan, who has left. There should be an amount on the second page. It's 2,500, Judge. I don't believe it's on the order, but it's on the second page of the motion.
What do you, and articulate for me what that's gonna go to?
Brandon Best with PPI Security to enable us to.
$2,500.
That's his.
That's his fee.
Yes.
No wrong business.
Normally it's 5,000.
I know Brandon. It's my first. Second one when we started. It's not. Okay, some not to exceed 2,500, so maybe it'll be less. That's signed and we'll get it or something. Probably that we'll use. God bless you.
Splash them.
Towel. I need a towel here.
I don't, was it Rick, everything else, consider them where probation, just put it on there.
On Jesse, go ahead.
This was Ms. Todd's case, we're going Mr. Pamplin offering this case. We're contemplating on whether to proceed with an open plea of some kind or whether he's going to accept potentially a lower jail amount. We'll just take this. I can't.
Vacuum cleaners.
It says $1,749.97. It's worth those things.
3 total vacuum cleaners, Dyson amounts, total does that amount change?
What? You were convicted in January of last year next door in the 252nd District Court, correct? What was your sentence there?
The locations.
Yeah, last year.
The last one?
Yeah, the last 23 CR 1244.
16 months, sir.
16.
That was, but it's twice. You never know on that, it's the same thing.
What's your call number, Judge?
1244.
From January 9th, 2024, Judge.
Yes.
He's correct, 16 months.
In June 22nd, 2023, the 400th District Court of Fort Bend County, what did you receive for that? That was in 23.
They gave me 2 years state jail.
To be exact, 706 days state jail is what he received there.
Yeah, and I want to use it, because like I said, it's really good. Be mad.
I'm repeating what's on the judge's page.
706 days.
Yeah.
Well, okay.
Yeah, this stuff.
When were you released from jail out of the one next door?
On the existing sentence?
Yes, sir. Do you remember when you were released?
Like June 17.
Yeah.
Of last year?
Yes, July. You can keep on, July is going to keep this. July is single pass mid-July, that's yours.
What is your bond? How much is your bond?
Like 18,000 right now. Start using, I've been making payments on.
How did they ever came up with that? Wow,
That's a great question.
how much time?
3 weeks, Judge.
You got 3 weeks.
That's what next thing.
Might as well take it.
Live honestly, sir.
All the property was recovered at the city, Judge.
Still, but
I know your intention to that information, Judge.
yeah, it's important, but it doesn't stop the problem.
No, sir, sure.
That they are able to catch him at the scene. He's got to stop making those choices.
They don't say.
Renata Taylor.
She's a plea judge.
Renata Taylor, please. 35725. You're talking to somebody else. We'll be back. That lady's going to swear you in. Thank you.
Please raise your right hand.
What are you doing? Raising your right hand.
Raise my right
Are you going to take up? Are you going to do the plea? She's going to plead on something. She's going to plead on something here. I want to see it. Yeah, you don't want to plead on this one.
No, I'm.
235725 is now called the state of Texas versus Renata Janice Taylor. Is that you, ma'am? Yeah. Present with your attorney, Ms. Minaldi, and the state's attorney does the defendant waive a formal reading of this indictment and arraignment. Can we proceed in a summary?
Yes,
In summary, ma'am, this indictment alleges that on or about April 16th, 2020 in Jefferson County, Texas, you committed a state jail felony of interfering with child custody. Do you understand what you're charged with here? Oh. Oh boy, there's a bunch of writing.
Yes.
It looks as though this state jail felony is going to be reduced to a Class A misdemeanor of attempted interference with child custody. A Class A misdemeanor carries with it up to 1 year in the county jail and or a fine of $4,000 or both. Do you understand?
Yeah.
Or. I don't know why I said both, but that's the punishment range. You're right, and it takes about 5 seconds for what you wrote to appear. You don't have a clue how, what, if it's going to be lucid or not. Okay. Reduced. That's, So do you understand what is happening today, man? This charge is reduced from state jail felony to class A misdemeanor. You would be pleading guilty. And placed on deferred or unadjudicated probation. And this can be up to 2 years. Do you understand? Fine $300. There is no restitution or anything.
No.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this lesser included class A misdemeanor of attempted interference with child custody? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily and because you are guilty? Yep. I showed you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Yeah. Did you understand it? Discuss it with your attorney, or the contents all true and correct? Yeah. State's Exhibit 1 is tendered into evidence without objection as exhibits. Hold on. I'm going to write all this thing. Almost. I don't even want to look over it. It's such a long name of a crime that it's taken me forever to fill this out. All right. State's Exhibit 1 has been signed and reviewed, tendered into evidence, and is everything true and correct here? Yes. State's Exhibit 1 is part of the record for all purposes. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your right to a jury trial, annoyance, the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All truth will help you die. Yes. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes.
I'm going to follow this agreement and find that you are pleading guilty today voluntarily to this Class A misdemeanor of attempted interference with child custody from this indictment in 20-35725. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt instead and place you on deferred or unadjudicated probation for a term of 18 months. One and a half years. There will be terms and conditions of probation, which are normal and customary for this type of office. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in the state jail, which nobody wants.
Should be up to 1 year in county jail, Judge.
I'm sorry. Yeah, this is class A misdemeanor. Wait a minute. Your deferred or unadjudicated probation could be revoked if you failed on these terms and conditions of probation. Then you could be found guilty and sentenced up to 1 year in the county jail. Thank you. I'm looking at 18 months and the amount of the term. And that's okay. I think. Multitasking is getting harder. Thank you. Please see the probation officer. Thank you. Also, there was a fine of $300 as well that was ordered on Miss Taylor's case that must be paid as well as a term of probation. Yeah, done. Okay. Like having a root canal without that medicine. Okay, Dewan Walter.
I believe I need to go through some paperwork with him.
Is that you, Mr. Walter? You didn't do your homework? Come on up. You're Mr. Walter?
Yes, sir.
Here. Okay, and Mr. Manalvi is representing you today.
Yes.
This was set for, thanks, Johnny's. It looks like
It's
announcement.
an announcement, Judge, but I have some plea paperwork to go through with him. We will have a resolution today. I just need some time to complete that paperwork.
Okay, then stand by. Thank you, Devon Westbrook.
Devin.
Devon Westbrook. Where's Devon?
He's walking up.
Okay. And it's an announcement as well. Oh boy, this is a serious case, right? You're looking at up to life imprisonment. So,
Judge, I actually never received an offer from Ms. Staub on this case. I had meant to get with Mr. Ham yesterday, but I failed to do so. It was just a lack of scheduling on my end.
Yeah.
If I could have 4 weeks to get him to review. Okay. If I could have 4 weeks to get him to come to my office to review his media and to discuss the offer that was just relayed to me, I would appreciate that.
4 weeks, get a resetting.
Thank you, Judge.
That's actually so.
Carlina Solomon, Matt,
I don't know how I did it.
Carlina Solomon, 24 CR 1361.
Judge, still waiting on the video discovery on this one. I'm working with his military for the DA's office, gotten the discoveries that I have not gotten to you.
What's that, Amy?
Just one normal reset, Judge.
There isn't anything normal in this room.
4 weeks. Or the 30 days for
4 weeks, good, okay? Yeah, it's over a year old.
Yes, sir.
Okay.
Yeah, as soon as I get that one, we'll
Thank
visit and go.
Great, thank you. Get a resetting. Jackie Williams.
Judge, we just got the offer in this case. Mr. Williams has some video that he wants me to see. So they get one more reset, so they can show me the video that he wants me to see from the
How
bystander.
much time is this?
It will reach. We can follow it. That should be dispositive on one way or the other.
Reset 4 weeks on this, get a sentence.
I think
Then I'm going back, I've got Leon Goodman and Marcus Roy.
That's Mr. Daniels, we already moved those.
We did already on odd one. Okay. What was it, Brent?
I was just making sure the other two that you've given me, I think they both are set.
They have. Highlighted and
We've got still this gentleman. What's going on here?
He's mine.
He's filling out an indigent form.
Might still
He's not, Langston wasn't here today.
There's I had a look today. Down and
Ross? Oh, yeah. No, that was reset. Mr. Adams available today.
So he must have called us and reset and didn't get back with you. But are you going to give him a resetting?
I didn't get to be sent.
Either one.
He's in, let me see. That's an app. Nice. Yeah, sure. All right. If they somehow get Shaw. Did they just call me? Who did? Okay, that's off. Jasmine Marie Holiday, 24W834240. All right, Liz Holiday, your name again.
Jasmine Holiday.
Raise your right hand and solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got. Oh, you pled to assault and battery under HIDA a year ago. That specifically, I sentenced you August 7 of 24. Since then, have you been arrested?
I've gotten in trouble for, my license got suspended. And I got in trouble for that, but I got all my clearances that I needed, and it was just for unpaid tickets. But I completed the terms of everything, community service, the court work program, I paid all my fines, I did the classes, I've completed everything since.
So you got a ticket for suspend? Was it pled to suspend or was it pled to something else? Let me see here.
I
John,
didn't even know it was suspended, it was suspended over,
I need him one more time.
Mr. Yurt?
Yeah. All right. Any other cases that you have pending?
No.
What are you doing for a living right now?
I worked at the same place for 9 years, I'm a manager at a restaurant in one.
Which restaurant?
The Waterfront.
Okay.
Yeah. Yes.
I just wasn't gonna lie.
Okay.
Well, I'm asking if I find trouble, I was gonna be honest.
You're kidding. Somebody wasn't gonna lie to me? Huh?
No.
That's a good thing. Maybe you'll learn something.
Oh, yeah, definitely.
Some people think that's fashionable. I'm just gonna tell the prosecutor that you had the conviction for whatever. What did you plead to? No ops?
I'm not even.
Allowing the licensed driver to drive? Something like that? I hate to keep bothering you. Your name?
William Ewing, out of the city of Woodhaven, Your Honor.
She got ticketed for driving on a suspended. And I can't see for the life of me what they pled her to.
On the disposition?
But at any rate, even if she pled to suspend and she says she got a new ticket or a new,
The clearances by me.
she got all the clearances, I'm still good with you dismissing. I just wanted to tell you about this.
Understood, Judge. Yeah, I think, since we're not dealing with what they're now classifying as a quote unquote serious misdemeanor under MCL 764, it looks like the intent of the delay was met, so to speak.
Yeah, and it looks like the only thing I'm seeing on here is no proof of insurance.
Yeah, that's
From Wyandotte. So your case is dismissed. Best of luck to you. I wish you well.
So.
Thank you. Thank you. So tell Vinny, if you would, as soon as this interpreter comes in, the Sunday interpreter done. And
It's Robert.
we don't have anything else down there, do we? All right. You wanted to talk to me, young lady?
You want to help Rosato?
Me?
Yeah,
Now?
you want to?
Well, I need to like prepare myself. I need to ask like a list of questions, but I need to prepare myself. Because last time.
Don't, you're fine. Relax. I'm not that hard to talk to. Come on, you want to go in the chambers? No problem. No problem. Don't be nervous. Okay.
Okay.
Here.
Yeah. Testing.
Or 8. Deontay La Diawand Law. 25F243345 A, B, and C, and I also have 25B148445A.
Thank you, Judge. As we get the parent behalf of Mr. Lawrence for the state for the record.
Yeah, say about.
So what is he going to do here?
Help me work with the
Mr. Law, why didn't you stay with any of these payment plans?
I lost my job.
Did I not? Did I forget to tell you to come in and talk to me if you didn't have the money? I told you, I didn't tell you that?
You said that.
Why didn't you come in and talk to me back in May? You could have Zoomed, you could have come in. You know, you make this hard on yourself. Do you have a new job now?
Yeah, I just got a job offer 2 weeks ago. My first day was yesterday.
Where at?
Viral diagnostic,
How much do you make?
2175.
Let's just forego this. I don't need to go through guilty pleas. I'll dismiss the show causes, but if I'll set up a payment plan, but if you do this again, we're gonna have a problem, okay? All right, tell me how much you can afford to pay per week.
You can do 100.
Do you get paid weekly or bi-weekly?
Pay weekly.
You sure you can do 100?
Pay more if I can.
I don't need you to pay more. I don't want you to go bankrupt here. You pay $100 per week I'll make it 75. How's that? If you want to pay 100, you can. 75 per week. And we'll start this. Today is the 1st, 3rd, 10th, 17th. How about October 17th or 24th?
17.
Okay. So Lisa, I'm just writing it on the misdemeanor file here, please. So you could just on 3, 3, 4, 5, A, B, and C, you can just set up the plan along those lines that after he pays on this one, he'll pay on the others. Okay?
Just to verify, the amount balance is 840.
I didn't add it all. I believe it's 220, 227, 213, that's 440 plus 225 is 665 plus what do you owe on this one again? 340. So that's 965. That's 1,005.
1,005, but the ROA, that's why I went to verify. The ROA says 840, Judge. I just want to make sure we can correct. No.
Which,
I don't know what you're talking about. Can you tell? Let me see here. Pull his name up, please.
Your calculation was right, Judge.
What's that?
Your numbers were right.
So it's 1,005.
It's 1,005.
Correct.
Okay.
You got 10 weeks, okay?
Okay.
All right. You go down the hall and she'll give you a printout. Thank you. Mr. Judicial, good morning. I have the Nasser Ahmed Mohammed Nasser 25W839908. Good morning, Mr. Judicial. Your name?
Good morning. Samer Jadala, P62186, appearing on behalf of Mr. Nasser.
How are you today?
I'm fine, thank you, Judge.
All right, so you're going to plead to impeding on behalf of your client. This was a commercial vehicle. The charge was 1 to 5 over. Good enough. So you're authorizing this plea on his behalf to impeding?
Yes, Judge.
To that charge, responsible or not responsible?
Responsible, Your Honor.
All right, we'll make it 175, fines and costs due by by October the 8th, a week from today, okay?
Yes,
I also have Nicola Cocan, 25W839915. All right, your appearance again.
And Your Honor, Samer Jadala, appearing on behalf of Mr. Cocan.
All right, so you're authorized in this plea on behalf of your client to impeding, right? Same thing?
That is correct, Your Honor.
All right, to that charge, impeding traffic, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted to that, 175, money due by October 8th, okay? Have a good day.
You and your staff have a wonderful day.
You too. All right. Okay. So these are all together. Charles Lester Laney, 25W839811 A, B, and C, and I also have 25W839812.
Good morning, Judge. As you get down, behalf of Mr. Dean, Mr. Dean, take it for me.
All right, so we have a charge of possession of drug paraphernalia, and we also have a charge of driving on a suspended as far as misdemeanors are concerned, and then speeding and no insurance for purposes of arraignment on the drug. All right, good enough. Allegedly, what kind of drug?
It did not specify. The note said was paraphernalia and not reading.
I see, okay. Metal spoon cap hypodermic needle, it says. All right, good enough. Not guilty, pleas entered, $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. Do you understand all that, sir? So you can fill out a petition for a court-appointed lawyer. You're going to need to do that going forward. Where do you work at? Okay. All right. So you fill out a petition, but I'm going to appoint you a lawyer. I'm signing the order granting discovery. We're going to give you a new date, and that date will be on what?
October 15th at 9:45.
Okay, October 15th at 9:45. Okay?
Yeah.
So you fill out your petition that he's going to hand it back to my court officer, go down the hall then, sir, and you're going to get your notice, okay?
Okay.
Good luck. Is that Rainy lady on there, Lisa?
She's on Zoom.
Has she met with the defense lawyer yet?
No, no one's logged on yet.
Okay. Do we have somebody taking care of that, John? We got to make sure there's a lawyer.
Which one you're on?
Rainey, the female that's in treatment. So I'm gonna need either probably,
And
I don't care if it's Mr. Westmoreland or Mr. Shemke or Mr. Crawford. You need to have that, Lisa, okay? I mean, figure out for him who we should send that to. I don't know.
He already gave it to someone.
Okay, you did? Okay.
Yeah, Randy, yeah,
Jeffrey Washilewski. 25W839-262.
wait to the podium.
Morning, Mr. Hart.
Good morning.
Mr. Washilewski, your name, please.
Jeffrey Washington.
All right, Mr. Hart, your appearance.
Mark Hartman, on behalf of Mr. Washington.
Okay, let's see.
We just got some video, so I gave him the June side.
Okay, no problem. 15, good. We can do 8:30. We can do 10 o'clock.
10 o'clock.
10 o'clock.
Actually, that's something I agree. I could probably do 11.
Okay, that's fine. Yeah, we'll make it 11 a.m., October 15th, okay? And sir, you're going to go down the hall and get your new notice, all right? Anything else? Have a good day. Thanks. You too. Thanks. Ebonique Allen Hunter Smith, 22W8299443A and B. Let's see here. Are you Ms. Hunter Smith? Okay, come on up. Your name?
Ebony Smith.
All right, you're charged with operating while intoxicated. And you're also charged with resisting or obstructing an officer. You have the right to an attorney. Would you like one? Okay, we'll set you up with a lawyer. You're going to go out in the hallway. Just be patient and the lawyer will meet with you then, okay? And then either way, you'll come in here with your lawyer after he or she has spoken to the prosecutor, all right? Good luck. Right out in the hallway. Thank you. How you doing, Lieutenant? Good. The interpreter hasn't shown up yet?
Not sure with me, Your Honor.
She's running a little late.
Okay. Is it Ms. Villarreal?
Yes.
Okay. Okay, people against Patterson. Rasheed Green Patterson Jr. 25W839-530. All right, good morning.
Judge Patton, that is P76343. I'll file an appearance shortly.
Pardon?
I'll file an appearance.
We'll have you do it now. We're gonna hand you a paper right now, okay? We'll hand you that and then I'll call it. Just take 30 seconds, fill it out. I have nothing else here. I'll recall it, all right?
Sorry, Judge, it wasn't.
That's okay. You're fine. All right. Let's see here. Okay, counsel, recalling Rasheed Patterson, file 25, W839-530. Okay, your appearance again?
Patrick Nine on behalf of Mr. Patterson. Please state your full name, sir.
Rasheed Patterson Jr.
Good morning. So does he stand mute, wait formal reading?
Yes, Judge, yes, thank you.
Did you pre-try this with the prosecutor?
No, I had to get him arraigned first before I could pre-trial, but we're gonna go do that right now and come back and probably plea this over.
$500 personal bond, sir. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Do you understand that? Okay, so you go out in the hallway. You can take the file counsel or go over into the prosecutor's room and meet with the prosecutor, okay? Have a good day. Marquell Damond Ingram, 25W83641A.
Good morning, Your Honor. Hassan Suaidan, P87558, here on behalf of Mr. Ingram.
Mr. Ingram, your name? Is he with you?
He should be. I just spoke to him. I know he was logging in. I don't think he got in yet. Would you allow me 2 minutes to give him a quick call and tell him to log in?
Sure.
Thank you so much.
Everybody's ready on it.
What's your name, sir? What's your name? Okay.
Hang on.
All right.
You don't have to think about it. Yeah.
Toscano? Bruce Laguardo Toscano, 25W839605, A and B. Good morning.
Good morning, Your Honor.
All right, your name, please?
Yes, Evelyn Dillable, certified court interpreter, CPA 22.
All right, I'm going to ask you to raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the defendant.
Yes, I do, Your Honor.
Sir, could you state your name, please?
Repeat su nombre,
Bruce Laguardo.
Bruce Laguardo.
All right. You're charged with driving while unlicensed
Ordenan acusado de estar manejando sin tener licencia
And
de
no-
conducir.
and no proof of insurance.
No tiene comprobante de seguro de vida.
You have the right to an attorney.
Tienen derecho de tener un abogado.
I'll be happy to provide you with one now at public expense if you would like one.
Y yo con mucho gusto que le nombre un abogado defensor ahora a costo público si usted le gustaría.
Would you like a lawyer?
¿Ahí está teniendo un abogado? Yes.
Okay, we'll set you up right now.
Pues ahora mismo le vamos a.
And then either way, you're going to come back in with your lawyer and Ms. Villarreal
Yes.
after you're done. Okay? Thank you. Thank you. Is your client in yet? Oh, Markel Demond Ingram, 25W8386418. All right, counsel. Good morning again. Your name?
Good morning. Hassan Suaidan, P87558, here on behalf of Mr. Ingram.
Your name, Mr. Ingram?
Markwell Ingram.
All right, so this is going to be a plea. The prosecutor is going to take the plea to, or allow him to plead to impeding, right?
That's true, Your Honor.
With the understanding that the drive while suspend will be dismissed, true?
Yes.
All right, is that what you want to do, Mr. Ingram? That's 0 points. It won't go on your record.
Yes, sir.
The charge impeding traffic, do you plead responsible or not responsible?
Responsible.
I'll accept the plea, dismiss this drive while suspend, revoke, denied. 225 is your total fines and costs. You can pay that today?
Yes, I have to pay. Can I pay it online?
Yeah, you can pay it right online, 33court.com with your case number, okay?
Okay, thank you so much.
Have a great day. Thank you.
Thank you, Your Honor.
All right.
Thanks a lot, counsel. People against Ramel Lavertus Howard Jr., 25W838526. Smith Davis will be next. Your name? All right, so you pled guilty previously to resist and obstruct an officer. And the plea was taken under section 771.1. Meaning that I'll set terms and conditions of probation. If you're compliant, you'll come back and the case will be dismissed. Do you understand that?
Yes.
You have the right to an attorney. If you want a lawyer, I'll be happy to provide you with one. Would you like a lawyer? You had a lawyer represent you before, didn't you?
Correct.
I'm sorry. We're going to get Mr. Crawford in here. Have you talked to Mr. Crawford yet?
Yes, I just left. So
If you want to go get him, I'll take this one right now.
I go back now.
Okay, I'm going to go off the record, please. You don't have much respect to understand.
Here,
Said what?
he said he'd be here, like I said.
Yeah, just wait right there in the front row if you would. That's okay. People against Ramel Lavertis Howard Jr. 25W838526.
One to run like a law. Been association into the record.
Mel Howard Jr.
All right, counsel. So your client pled to resist and obstruct under 771.1. Have you had a chance to speak with him? I did not order a pre-sentence report.
I did not. I reviewed this. My client understands that he could have conducted himself better and it would lead to this misunderstanding. He won't do this type of thing again. You know, he's sorry for his conduct and he understands how to better handle it in the future. You're right. Just want to get this put behind him.
Anything you'd like to say?
It was just a misunderstanding.
You kicked him. What are you kicking an officer for? You have an answer for me?
Just a mistake.
Not a mistake. That's an intentional act. That is an intentional act. That is not a mistake. You don't have much respect for police, huh? They kept calling you, telling you to stop. You didn't do that either. Then you decide you're going to kick them. You just tell them. Did you work, counsel?
Yes, Your Honor.
Where?
I worked for my father here at the home improvement company.
You work a lot?
Yeah, it's picking up more now.
I'm sorry?
Yes, it's picking up more now.
How old are you?
Thank you.
report wasn't in the file, so we had to order it this morning. And I'm just taking another quick peek. Yeah. 6 months probation. If I let everybody finish, and I will take it under section 771.1. If I let everybody finish?
Yes, sir.
You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're not to return to 23300 Allen Road or any other Home Depot store. You're to serve 1 day on the court work program and pay $35 for that. You're not to have any contact with the victim in the case. You're to serve 1 day of community service. I'm going to give you until November the 15th to do that. You're going to pay fines of $100, costs $100, $75 victim's rights fee, $50 justice assessment. So fines and costs are $3 1/4. You have your court work program fees of $35 for $360, and you also have court probation fees of $120. So that makes for $480. I'm also going to assess attorney fees of $40. Your total's $520. You pay that, you stay out of trouble, you come back for your review date. I'll be happy to dismiss your case on motion of the prosecutor. But you have to be compliant with everything. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes.
Lisa, give me a prosecutor review date, please.
March 18th of 26 at 9 o'clock.
March 18th at 9 o'clock. March 18th of 26 at 9 o'clock. Okay. Can he pay all of this today?
No, Your Honor, my client needs a payment arrangement. What we would propose is to pay $100 in rent. It should be done timely.
Why? She's going to have to do better than that. You need to work more. Aren't you?
I mean, he works for the family business. He doesn't control the contracts.
Well, I know, but if he's only able to pay $100 a month at 28th, then he better find 2 other jobs. I'm just telling you. You're going to pay $100 bi-weekly. And we're going to start this beginning on October. I'll make it October the 24th. But I'm serious. You're saying it's picking up now. If it isn't keeping you busy for at least 40 hours, you better find another job. Right? You need to show more respect for authority, young man. You don't kick police officers. Thank you, Mr. Crawford. You'll meet with probation before you leave. Thank you. Naquan. Kenneth Smith Davis. 23W833, 381, A and B, and 25W837, 392B.
Representing the station.
Naquan Smith Davis.
So he's going to plead to allowing an unlicensed driver to drive. They're going to dismiss the suspend. And then let's see. He's dismissing the plate charge.
Correct.
And then he's going to have to pay, and there's no insurance. So
Paid that, Your Honor, so the court knows.
okay, if you plead guilty here to allow an unlicensed driver to drive, excuse me, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign the advice of rights and read and understand the rights?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes.
All right. To the charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a motor vehicle on December 1 of 23 in the city of Woodhaven, county of Wayne, that was being operated on Western Island?
Yes.
And You were suspended and knew that at the time you were operating the vehicle. Is that true? Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
I'm gonna accept your plea on that charge to allow an unlicensed driver to drive. That's file A. Dismiss the suspend on file A. Dismiss the plate charge on file B. And then I have 837-392B, where he's going to,
That's a different defendant.
Oh, geez, thank you. Yeah,
Yeah, everybody got that mixed up.
thank you. Okay, thank you. All right, you ready for sentence?
Yes, Your Honor.
Anything you'd like to say?
Nothing, Your Honor. My client has a valid driver's license now, intends to keep a valid driver's license. The proper plate issue has been resolved, sold that vehicle. And you plans on staying on this side of the law here on out. We appreciate working to take that in mind when issuing the exit policy.
All right. Anything, sir?
Tell me that I'm losing some of this when I at this moment.
100 fines, 80 costs, 75 victim's rights fee, $50 justice assessed. So your fines and costs here amount to $305. Attorney fees are $40. Your total's $345 of 90 days. He has a bond.
That's true. I believe it's 400. 200 on each charge, 200.
Let me double check. I only show 2010%, Lisa. Am I missing something?
There's another bond. Let me look at that one. That's a Judge Hessen case. Set for today. I'm sorry,
Okay.
set for tomorrow. Flat Rock case.
So you got 180 to apply because by law we keep 10%. Do you have the other $165?
He doesn't have that today, Your Honor. What we're proposing is that it pays $50 every 2 weeks.
Where does he work?
So, sir, where's asking where you working out?
I'm trying to get in the bail time right now.
180 now. You pay $50. I'll make it bi-weekly. Where did you last work?
I was working for myself.
Starting October 16th, $50 bi-weekly, starting October 17th, rather. If you don't have the money, no problem. Call the court. We'll go on Zoom, or you can come talk to me on it before the due date, 8:30. I'll be glad to give you an extension. I don't care how many times we have to do it, okay? Don't ignore me. Good luck. Thank you. Gregory Tyrone Smith Jr. So you have to go down and sign your bond over. 25W837392B. Is Mr. Smith here, Lisa? Is he on Zoom?
He's here, Your Honor. I called on
Zoom.
Oh, he is on Zoom? Okay.
Yeah, he's coming in right now.
Why? Did you represent him before?
I had his file, but it was mixed in with.
I see. Mr. Smith, you have to start your video, please. All right, let's go on to McWhirter. Caleb Rose McWhirter, 25W839-805A and B.
McWhirter, approaching.
Your name, ma'am? Does she stand mute, waive formal reading?
She does, Your Honor.
I'll enter a not guilty plea. Now she's going to plead to no ops on person with the suspend to be dismissed. True?
True, Your Honor.
Is that what you want to do, young lady?
Yes, Your Honor.
If you do that, the possible penalties are up to $100 fines, 90 days jail, costs are all those. Do you understand that? And did you sign an advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Any questions before I ask you how you plead?
No.
To the charge, no valid operator's license on person, how you plead?
Guilty.
Were you operating a motor vehicle in Western Island and Woodhaven on September 5 at 25 at 10:36 in the morning?
Yes.
Do you have a valid license with you on your person?
I don't have it on me.
No.
Did you?
Did you?
Oh, no.
Are you on probation or parole?
Yes.
You are now?
Yes.
For what?
OWI improper transport.
Were you on probation on September 5th?
Yes, I just got on probation in middle of August.
Do you understand by pleading guilty here, this would be deemed a violation of that probation? That probation could be revoked. And
Yes.
you could be incarcerated on that charge as a result of this plea and conviction.
Yes, I already spoke with my probation officer.
Do you understand what I said, though?
Yes.
You still wish to plead guilty? Anybody promise you anything to induce you to plead guilty?
No.
Where are you on probation?
Where? Through the Third Circuit Court.
What are you doing in the Third Circuit Court?
It was because of the firearm charge.
Okay, so they reduced it in circuit court. I'll accept your plea. I find it to be an accurate plea. Here, though, you gotta be careful,
Yeah.
right? All right. Counsel, what would you like to say?
Nothing other than, Your Honor, my client understands that she shouldn't be driving, she won't be driving. She discussed with me a plan she has in place. I heard it with her and her fiance. She's gonna get moved about, so she doesn't intend on picking this up, and she takes the original probation matter very seriously. So she doesn't want to get in trouble she already got herself into.
Anything you want to say, ma'am?
No, Your Honor.
100 fine, 75 costs, 75 victim's rights fee, $50 justice assessment, $40 in attorney fees, $340 or 90 days. Can you pay that now?
She can't pay it all now, Your Honor, but she can pay $270 today. If you give her 2 weeks, she can.
Sure. You pay that today and I'll give you until the 17th. $270 now, balance by October 17th. Again, if you need more time, come talk to me, okay?
Thank you, Your Honor.
I wish you well. That's it. Good luck. Thank you. All right. Let's real quick take Gregory Tyrone Smith Jr., 25W837392B. Mr. Smith, your name? You gotta start your video, sir. Or I'm sorry, unmute. Unmute.
Can you hear me now?
Yes, your name?
Gregory Smith Jr.
You pled guilty to failure to pay $282. Today's the sentence date. You have the right to a lawyer. I'll be happy to give you one at public expense if you want one. Would you like a lawyer?
Sure.
Judge, he's assigned to Mr. Crawford. He's got a pretrial also. Somehow his cases got separated.
Big stuff with.
Can you take this one down?
Yeah, I will, as soon as I talk to him, give me a couple.
Yeah.
Okay.
Okay, sorry about that. We'll set you up with your lawyer here. Give us a minute. Thanks.
Okay.
Who? Gregory Smith. Not Gregory Smith. That's what we got all mixed up. That's my guy, David Smith. Now it's Gregory Smith. Files it, here somewhere.
Trial, so it should be with the prosecutor.
Yeah, that should be with the prosecutor.
Yeah, but I had the whole file with this at some point. Remember you called it earlier? I'm gonna go check the prosecutor.
Yeah.
You're firing. People against Patterson. Receive Patterson Jr. 25W839530. All right. Good morning.
Good morning, Pat, nice to meet Mr. Patterson. You can say anything for the court again.
Your name, sir?
Rashid Patterson Jr.
All right, so the OWI is going to be dismissed if he pleads to operating while visibly impaired, and that's what the arrangement is, correct?
Correct, Judge.
If you do that, the possible penalty, if you plead to operating while impaired, is up to $300 in fines, 93 days jail, 360 hours community service, court costs, or all those 4 points. License suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that, sir?
Yes, sir.
Did you sign an advice of rights? Did you read it?
Yes.
Understand it? If you plead guilty, you'll be giving up all those rights and we will not have a trial of any kind. You understand that?
Yeah.
All right. To the charge operating while impaired, how do you plead? Were you operating a motor vehicle September 14 of 25 at 3:51 in the morning on West near Heritage Drive in Woodhaven?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes. Adam. You say bottle of you say
A bottle of what?
Is that liquor?
is liquor, bottle of liquor. It's funny. You say
Okay. A fifth or a pint or what?
idea. Bit.
And did you drink some of that?
Yeah.
How many shots did you estimate that you drank of that?
3, 4.
Okay, regular shots or just chugging it out of the bottle?
Regular.
Was your ability to operate that motor vehicle impaired because of the consumption of the alcohol? And if so, in what way?
Yes. What way?
Yeah, why were you pulled over by the police?
Last speeding.
You think you were speeding at least in part because of your alcohol consumption?
Yes.
Did you take an intoxilizer, a breath test, or a blood draw?
Yes.
Breath test, I will stipulate it's 0.16 at the station, I think it's 0.15 on the low side sobriety test.
Oh, okay. And are you on probation or parole right now? Has anybody forced you to plead guilty?
No.
All right, I'm gonna accept your guilty plea. I feel like to be an accurate plea made voluntarily and understandingly. Please accept the operating while impaired. The OWI is dismissed. I'm gonna refer you for a screening and assessment. I am gonna have to add a condition now that you attend AANA at least one time a week. We're gonna hand you a form. You have to go in person. Every time you go, you have to have the forms. Every time you come to court, you have to bring the form with you, okay? So we'll hand you that AA form and you'll go down the hall. We're first gonna give you a sentence date. You go down the hall and pick up your paper notice and then you'll go over to probation and fill out a questionnaire and be interviewed. So what do you have for me, Lisa?
October 15th at 8:30.
Good with you, counsel?
Yes, as a judge.
October 15th at 8:30 in the morning will be your date, okay? All right, so you know what you're doing now, right?
I guess.
Okay. Anything else?
I just don't want to confirm the time, it's 8:30, Judge?
8:30.
Okay, thank you.
Okay. So down the hall notice, cross the hall probation. Best of luck. Thank you.
Thank you very much. Judge.
Thank you.
Appreciate it.
I'm
Your Honor, Judge will honor speed 36431 on behalf of James Freiberg.
Sir, your name?
James Thomas Freiberg.
So your client pled guilty to operating while impaired. He was referred for screening and assessment. Probation prepared a report and recommendation. Have you had the chance to review that with your client?
Yes, I have
Any material additions, corrections, or deletions?
no material additions, corrections, or deletions, Your Honor.
Anything that you would like to say on his behalf?
I'd just like to say briefly, Your Honor, this is his first contact with the criminal justice system. So he has a great track record. I think the recommendation and review of the testing instruments are reasonable given the circumstances. I'd ask the court to adopt the recommendations. And my client is going to be sentenced, Your Honor. He's I don't think he has anything to add.
Okay, I'll ask you, anyone, do you have anything else you want to say?
No, here.
Well, let me read you something. I observed a blue pickup truck traveling at a high rate on West Jefferson, South Lane. I turned around and attempted to catch up with this vehicle. I observed my speedometer to be exceeding 100 miles an hour while this vehicle was still pulling away from me in a posted 45 mile per hour zone. Is that true? What in the world were you thinking driving around midnight on Jefferson at 100 miles an hour?
He explained it to me.
I want to hear it. Tell me.
I disagreed with that, Your Honor. I didn't believe that I was driving that fast.
How fast you think you were going?
So vehicle I was driving at the time, approximately about 60 miles an hour, 65.
That's quite a disparity. He thinks you were traveling. He wasn't gaining ground on you when he was 100 miles an hour. You're saying 60, 65. That's quite a disparity. I'm just telling you. 14 months probation. I mean, you got to use your head out there. Jeez. 100 miles an hour on West Jefferson? Wow. That's like driving 135 on I-75. 14 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll then make it monthly. Okay, so if you're clean for 4 months, I'll make it monthly testing instead of bi-weekly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend AANA at least once a week until you're in intensive outpatient treatment. You have to attend an intensive outpatient treatment program with aftercare as recommended by the treatment agency, okay? So AANA once a week until an IOP. Once you get in an IOP, you can stop going to AA. And you're also to attend the Victims Impact Panel. And you do have your proof that you were going once per week, correct?
Yes, sir.
Okay, have you seen it, Mr. Boulan?
No, I haven't.
Okay,
By the way,
so
you
you'll,
showed it to me last time.
okay.
Yeah, he's got it right here.
Is he gone? All right, good enough. So do you understand the sentence so far?
Yes, so I need to go to find an NA,
AA or NA?
AA is fine.
Either one.
oh, either one, not both.
Correct. Correct.
Okay.
And then you do that once a week until you're in intensive outpatient treatment. Once you get in intensive outpatient, you don't have to do it at all anymore. Then you're going to also go to the Victims Impact Panel. You're going to serve 5 days jail credit, 1 serve 4. I'm going to let you serve those on the court work program. $35 a day charge for that for a total of $140. Okay, $300 fines, $275 costs, $75 victim's rights fee, $50 justice assessment. So fines and costs are $700. Probation fees are $280 for $980. You have cost of recovery, which is $150, bringing your total to $1,130, plus the screening fee of $60 for $1,195, plus the court work program fees. Your total's $1,335. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And also, you may be eligible for early discharge. So if you get everything done in 7 months and there have been no violations in the preceding 90 days, I'll be glad to give you an extension. I'll be glad to discharge you, rather. Do you understand that?
Yes, Your Honor.
Okay. So he has $1,335. Can you pay that?
Yes, yeah, that's today.
And you'll meet with probation. I'm telling you, I'm really concerned. The thing that alarmed me the most is you driving like a maniac.
I talked to him.
All right. That's why I did what I did, a little harsher than a first offender at 45, but whatever. Good luck.
Thank you.
Thank you. Justin, good to see you, Mr. Boulan. Justin Robert Rodriguez, 25B148009. Your name?
Justin Robert.
You got the money to pay this?
I just got off unemployment Trying to, I'm not gonna do on it, but I just started a job this week
Where?
at the average cement company
How much can you pay per week?
per week. Probably better per month right now. But I get back on the.
Tell me when you can start paying how much?
Maybe in 2 weeks.
How much?
50.
A week or bi-weekly or monthly or what?
Roughly.
You're asking for a lot. You pay $50 bi-weekly beginning October 15th, okay? You don't have the money, come talk to me, but you don't have a valid license because you're in suspension on this and you gotta pay the ticket and pay your clearance.
Yeah, how much is it?
I believe, and I believe the total's 327 now,
Okay,
okay?
yeah.
All right, best of luck.
So if I pay that, I can have license back.
Well, I don't know. I don't know the rest of your traffic record. I just know you're suspended because of this, for
It's
sure.
362 with the suspension.
362 with the suspension. But I'd have to look at your traffic record. Let's see. Yeah, I mean, it looks like you also got a no proof of insurance. Oh, no, in 35th District Court that you're suspended on, and I don't see where that was ever terminated. So that's in where Canton or Plymouth, I believe.
Yeah, I'm in the middle of working on that.
All right. Wish you well. Good luck. Rafael Garcia Bequez, 25W39564. Good morning. Nice to have you here. How are you?
Nice to see you, Josh. Well, and yourself?
Good, thanks.
Crystal Marie Medina on behalf of Mr. Viquez. Your Honor, my client does require the services of a Spanish interpreter.
All right. Ms. Villarreal, your name again.
Lynn Bill, certified court interpreter, C3822. I was not assigned to this case, Your Honor, but I was here and I'm.
You're just so kind. You're nice. Thank you very much. Raise your right hand. You solemnly swear from that you'll make a true and accurate translation between the court and the parties involved.
Yes, I do.
All right, sir, can you tell me your name?
¿Tenía puede usted decirme su nombre?
Rafael Garcia Víquez.
Rafael Garcia Viquez.
All right, does he stand mute and waive formal reading?
That is correct, Your Honor. We would wait formal reading and stand mute, and we would be requesting another pretrial date, Your Honor, with the hope that we will resolve it by that date.
I'm going to enter an not guilty plea for him. I'm going to give him a $100 personal bond. You don't have to post any money, sir. You cannot leave the state without consent of the court. You cannot violate a law. You must appear in court as directed. This says that he wants, he's going to get his license. Is that right?
No, Your Honor, he's not able to get a license, but we are taking certain steps that will put him in a better position to clear, I think, another ticket deed, just so that we can.
How long of an adjournment do you want?
I would say if we could have about 40 days, because we're having to clear something else.
40 days.
Yes.
6 weeks.
Approximately here,
No.
4 to 6 weeks.
Okay.
It could happen.
Yeah, I got it. Look, can you do it by October 29th?
Yes, that sounds perfect, Your Honor, and I think mine is on, yes, Your Honor, that works perfectly.
At 8:30?
That works well.
October 29th, is that good, Lisa, at 8:30?
Yep, that's good.
October 29th at 8:30.
Perfect. Thank you very much, Your Honor.
Thank you very much. Nice to see you. And we're gonna get another Spanish interpreter here and hopefully Ms. Villarreal here.
Thank you so much, Your Honor. It's nice to see you as well. Would I be seeing you tonight?
I can't make it tonight. I feel terrible. I can't, but I can't.
Thank you so much for seeing you.
You too. Thanks.
Case number again.
Sure. It's 25W839-554.
Thank you so much.
Have a good day. Thanks. Oh, yeah, right. Thanks. Thanks a lot. Thank you very much. Bye now.
Oh, Judge likes it. Okay.
And what's your name again?
Ludington.
Okay,
Do you want to do no shows?
sure. Jeanette LaRue Stutz, 25W839E23. Ben failed to appear. Open Intox. We're issuing a show cause. Lindsay Marie McLaren, 25W83882. This is an embezzlement charge. You'll be required to issue a show cause. That is what we'll do. Ulysses Jose Sequa Latinas, 25W839752. A and B, we're going to issue a show cause, and in the misdemeanor, we're going to issue a default judgment on the civil. And actually, I have a C file here too that was buried. So on the no proof insurance, count 2, file B, and on the disobeyed traffic signal, count 3, file C, we're entering default judgments on both of those. Tiffany Janelle Epperson, 25W839557A and B. And again,
Partially via Zoom, partially in person. Ms. Miller, who is here in person. And can you do the grid format for me? Is that a thing? All I see is Mr. Barnes. No offense, Mr. Barnes, but
Afternoon, Judge.
I don't see anybody else. Gallery view. There we go. Are we missing somebody?
At the bottom, that's his screen.
Oh, can you hear me, Mr. Kraken?
I can, Your Honor.
I'm sorry, can you hear me, Mr.
I don't
Kraken?
know if you can hear me, but
Oh, yeah, I can hear you. All right, so we are here
I can,
today,
Your Honor. Yes, sir. Okay.
for the purpose of a status pretrial update. What's going on?
I guess I'll lead, Your Honor. Man filed its notice of appeal and
Your Honor, we had some internal discussions about this.
Robin was.
We seem to be having some technical issues. So, Ms. Miller, why don't you start again? And did we lose Mr. McCracken?
Mr. Kraken is gone.
Is he gone?
He's gone.
Are you back, Mr. McCracken? Can you hear me, Mr. McCracken? Does somebody have Mr. Kraken's cell phone so we could maybe text him,
Should I just,
see what we know?
and let me email him, Your Honor. just sent him an email, Your Honor.
Hello, Mr. Kraken.
Is everybody? Good morning, Your Honor. I apologize. I'm traveling for work and the signal is not the best.
Okay, go ahead, Ms. Miller.
Thank you, Your Honor. Man filed its notice of appeal, and we do have a scheduling order with briefs currently due October 9th. We requested an extension until November 9th. I'm sure plaintiffs are wanting to set a trial date for the remaining 8. From Man's perspective, as I think we've discussed in previous status conferences, I think we all think it's in everyone's best interest to hear from the Court of Appeals. Not so much with regard to the fact witnesses. That discovery is largely done, just needs to be what I guess I would call refreshed. But as we know, there are a lot of experts in this case, and given the issues on appeal, I think it's in everyone's best interest that we hear from the Court of Appeals before we start engaging in the expert reports and the additional work for the experts.
Anything else on behalf of the defendant, ma'am?
Only, Your Honor, I think, I've kind of, based on experience with the 12th District and how the appeal went the last time, I would expect we're probably not looking at getting a decision from the Court of Appeals until perhaps late summer.
I think we lost Mr. Kraken again.
No, I'm here, Your Honor. There was just a lot of traffic, so I didn't want to distract anyone with my camera.
Okay.
So I think from Man's perspective, Your Honor, so that we don't have to redo any expert work or set a trial date and then bump a trial date, waiting on the Court of Appeals. From Man's perspective, we think we would be looking at probably February or March of 27 to schedule the jury trial of the remaining 8.
Mr. Kraken, where are plaintiffs at on that?
So, Your Honor, we actually talked about this internally this morning, and I think we have been persuaded that it is probably in everyone's best interest to wait until the Court of Appeals has had a chance to rule. So I withdraw my request for a jury trial, and I think we just hold status until we hear back from them.
I think it makes sense to go ahead and get a trial date in February of 27.
Okay. Actually, Your Honor, both Jake and I I forgot, that's got scheduled a couple weeks ago. We have a jury trial in the District of New Jersey scheduled for February of 27 that both Mr. Holcomb, myself, and Mr. Plattenberger are on. Is it possible that we could do April or May of 27?
April makes sense.
April.
Okay.
Assuming Thad and Dave are both available, April works for me as well.
What'd you say, Robin?
Is April of 27 okay for you and Dave?
Yes. May might be better for me, but so far out, I've got something, but you can't know what holds. I don't know what the court's availability is for dates, about 5 weeks. Mid-April starting.
Why don't we plan on starting on the 12th?
April 12th, Your Honor, 27.
let's set it for 4 weeks for now, starting the April 12th. And then we can adjust that as necessary. Let's go ahead and get it on the calendar.
Thank you, Your Honor.
Yeah,
What is it?
I was checking.
DH
Easter's
machinery
March.
pump
Okay.
installations. What is that?
That's why we set it out.
All right. So you guys are going to confer, you're going to put together a scheduling order that works backwards from that date. And we'll set it for another conference, maybe January.
That makes sense.
That works for plaintiffs, Your Honor.
I mean, obviously
great, Your Honor.
earlier if something comes up that you need us, but
Understood?
maybe we should wait until May 3rd. I'm worried about that other case. Why don't we do May 3rd for 4 weeks, so we'll block out May.
Okay, Your Honor.
May 3rd.
Okay?
Thank you, Your Honor.
Anything else
Understood,
for
Your Honor.
today?
Thank you. Nothing from me, Your Honor.
We're all set.
All right, we're in recess.
Thank you, Your Honor. Have a great day.
Thank you.
You too.
Have a good day.
Bye.
Go ahead and let Ms. Idle know to, I did not. Thank you. I didn't realize it was here. Or what I ordered in the first. Thank you. I didn't realize it was here.
Oh, yeah.
All right, that gets beautiful day for a walk. As usual, I ran into people to talk to. Do we know what your clients are doing? What does your client wish
We're
to
gonna
do?
make an admission of the violation today.
All right, and Tim?
He has not appeared.
All right. I'm not terribly surprised by that. But I
Communication with my
expected him to be here. All right, good afternoon, everyone. I just came inside a little still warm. We have a number of probation violations set for 1 o'clock. We're gonna get to those. Thank you for saying hello. I hope you all got Rocky Raccoon this morning because Tim George didn't. I thought that was really easy. All right, we're ready to begin our probation violation hearings. Attorney Casey Strong is with us by Zoom. She is in Kalamazoo County. She's awaiting a jury verdict. And so I agreed that she could appear by Zoom. Her client is Martin Luis Carmona. That's you, sir? Your probation officer is Daniel Frazine, and he's here with us. Sorry about that. Nobody wants to watch that. It is a beautiful day out there. For October 1st. This is file number, if I didn't say it, 241951. Mr. Carmona was originally charged with a felony offense of carrying concealed weapon, a 9mm handgun. That charge was reduced. The defendant was placed on probation. His probation officer, Daniel Frazine, has filed a petition alleging that he has violated the probation. He was convicted of attempted resisting, obstructing, and attempt to possess a firearm. Both of those would be 1-year misdemeanors. There was a condition of probation that he not violate any criminal law of any unit of government, that he report on a monthly basis, and they pay fines and costs, and that he not use drugs or alcohol, and test on demand, and he not use a firearms or drive a vehicle. The probation violation arraignment was, I believe, it was supposed to be September 5th in front of Judge Pattison, but it ended up, I handled it. He had some new charges in file 251282FY, and bond was denied, and the PV hearing was set in this matter. According to Mr. Frazine's status report, we sort of lost track of the defendant over the summer. Sporadic, he missed reporting in September, and then he got new charges, and Mr. Frazine is recommending substantial jail time. One problem always in a probation violation case where the defendant is charged with a new crime that has not yet been resolved is anything said in the probation violation hearing could potentially be used against the defendant in the criminal case. But there were a number of separate issues here, and Daniel and I discussed it, and he went ahead and filed this violation. I believe at this point, Mr. Carmona has been in custody for 13 days. Let me make sure I had that right. Ms. Strong, what does your client wish to do here?
Your Honor, I have unfortunately not been able to speak with Mr. Carmona in depth. I was hoping that we would be able to speak via Zoom prior to this, but as for the allegations in the petition, if he is going to make admissions, which I do know would be my recommendation here, I would ask that they be no contest admissions, only for purposes of liability in any future proceedings as related to the new charges.
All right, that's wise. Mr. Carmona, would you like to speak with your lawyer?
Yes, please.
All right, this is always a bit of a security issue because the Zoom room is outside the courtroom. But Laura, would you set up the Zoom conference room?
And again, Your Honor, thank you so much for accommodating this.
Well, you didn't know you'd still be in a trial, and so it's fine. We'll make it work, but we've got extra security out in the hall. So Mr. Carmona, I'm gonna have the court officer take you out in the conference room, and I'll stand outside the door while you confer with your lawyer. All right, while we're waiting, Ms. Yancey, let's take up your matter. I would know that Prosecutor Angelique Camfield has also joined us. Good morning or good afternoon. I'm not sure if anybody heard me. We need to open the Zoom conference room. The next matter we're going to address is People versus Tanya Marie Moeller. Ms. Moeller was charged with a larceny in this file, which is 23878SM. Let me click into this one. She was placed on probation, and her probation agent is Autumn Kiefer. She was charged with stealing a wallet containing $180 of cash that belonged to a Richard Roll. And she pled to that charge. We had some victim input and the defendant was placed on a probation. Ms. Kiefer filed a probation violation petition alleging that she fell off a map, essentially, that she failed to report on a monthly basis. That petition was last June. The defendant did not appear for that hearing and a bench warrant issued for her arrest. She got picked up a few weeks ago. She'd been in, I don't know where she was, but she was here. She'd been in jail in Calhoun County. She bonded out and then came here for her arraignment. She pled not guilty and asked to set the matter for a hearing. She's here with her original attorney, Jordan Harden.
Your Honor, I was not the attorney in the underlying case.
Oh, you weren't?
No, I was not on a contract at that time.
Oh, well, all right. You're counsel now. I don't know who was your original attorney. Do you remember who your original was?
I didn't have one here.
All right. Okay. Well, Ms. Harden, what does your client wish to do?
Thank you, Your Honor. I did have a phone conference with my client a couple weeks ago, as she does live quite a distance away from Centerville and Mendon area. Discussing the allegations of petition, she is willing to make an admission today.
All right, let me put Ms. Strong in the break dancing room and then we'll. I'm bringing Mr. Carmona in. Sometimes we need to multitask. In fact, most days we need to multitask.
Michelle, are we good? Can you hear us?
Yes.
Okay, great. Thank you.
Click the button that says join there, Mr. Carmona. All right. Returning back to the matter of Tanya Moeller. Ms. Harden, I'm sorry I interrupted you.
No, you're fine. The indication or the intention of my client today is that she's going to make an admission to the allegations in the petition, which was violation of Article 3, failing to report.
Well, let's talk about that. Let's talk about the status report. Her last report was April of 2024, and then we just lost track of her. So Ms. Moeller, would you acknowledge you failed to report since April of 24 until you got picked up in Battle Creek in August of 25?
I do, Your Honor.
What happened?
I ended up moving to Bay City, Michigan to attempt to take care of my mother and my stepdad, and just with the multitasking, it just wasn't a priority when it should have been.
When you got arrested in Calhoun County, did you get charged with anything there, or they just arrested you on our warrant?
On the warrant.
How'd you happen to be in Battle Creek?
Well, I was coming down to deal with my daughter and actually come here and deal with some things, trying to get things squared away in St. Joe County so that I don't have to do the 3-hour drive.
Well, I put you on probation because I felt there was a drug issue here, and I also wanted to have enough time to get restitution paid to the man whose wallet you took. But I wasn't very successful at that. Ms. Kiefer, what's your recommendation here?
Well, initially she has 20 days of deferred time. This type of violation doesn't warrant 20 days. She was served 4 days in Calhoun County that I verified. She unfortunately hasn't paid any fines and costs at all in this case. So my recommendation is for the 4 days of time served for her to pay the $325, which removes the oversight fees of probation and revoked from the probation.
Ms. Harden, having that in mind, what would you like to say to that?
Your Honor, we were going to ask for the court to consider her circumstances. I was not aware of the time she'd done in Calhoun County, so the new recommendation for time served and just pay the remainder of that restitution and court costs, we would ask the court to adopt that recommendation from Ms. Kiefer.
Ms. Campfield, do you have an opinion regarding this?
I do, Your Honor. I struggle with these types because it doesn't appear that there's a new offense or any criminal conduct, at least that we're aware of, that would have brought her before Calhoun County or this court again. However, if she was moving to Bay City, that's something that she should have kept Ms. Kiefer aware of. Probation could have potentially been transferred there if this court was willing to do so and they accepted, or perhaps even a phone report could have been arranged, but she didn't make effort to even comply in that regard. So here I understood she did 4 days and there's no new offenses, but when you just abscond and have to be picked up in order to come deal with things, I think that perhaps maybe a little bit more than the 4 days served is warranted for just snubbing her nose at this court. And frankly, Ms. Kiefer, who through her report made every attempt to help her report on several occasions and had to reach out to her. She failed to report in March of last year. She reported in April and not thereafter. So, I mean, she was giving her the benefit of the doubt and she didn't give the same respect back to this court or Ms. Kiefer.
Yes. Let me bring Ms. Strongest back. To back all the way up, this crime offended my sensibilities. This handicapped man left his wallet in a cart at Myers. You took it. You lied about it. You minimized it and took his money. Mr. Roll left his wallet in one of the motorized carts. He was with his healthcare worker. He had $180 plus all his ID, which by the way, has never been recovered. That's a huge pain to lose your driver's license, your credit cards, your social security information, your insurance. So they watched the footage and they saw you take his wallet. First you said you didn't take the wallet, then you said you did take the wallet and you gave it to a Walmart employee in the parking lot, which you didn't. You took his wallet and left and kept his money and all his identification. I thought you got a huge gift when I put you on this probation. I wanted to get the guy's money repaid. You repaid us by doing zero. And then interesting, when it comes time to get out of jail, you come up with money to post a surety bond. You can't pay 1 cent to us or to this man's restitution, but when it comes the difference of you sitting in jail and getting out, you come up with enough cash money to post a surety bond. So you deserve more than 4 days in jail. You deserve what I ordered in the first place. As I said, this offended me right from the get-go. My judgment was 6-month probation, 21 days minus 1, hanging 20 days over your head. You were supposed to pay restitution and court costs and other expenses, of which you paid none. I also barred you from Walmart for a year. So having said all that, what would you like to say to me?
First, I apologize to the court's and probation for having life problems. As of September 9th or September 10th, I am now working. If my check deposited on Wednesday mornings, $200 would have already been paid, but it doesn't until after midnight. So I can't pay anything until tomorrow.
All right, fair enough. Can you get his driver's license and social security
My-
card and his? Yeah, you threw somebody else under the bus. This
My
was all-
son threw all that away, or I don't know what was happening to it after it got in his hands.
Yes,
But I pled guilty because I am the one that took it out of the court. The cart there at Walmart.
well, yeah, you did.
Well, my son's also 39 years old at the time.
Yeah, you got very little responsibility for this. The more you say, the more I want to give you the balance of 21 days in jail.
I would appreciate not, Your Honor. I have a
Yes.
mother and stepdad that I need to provide care for.
Yes, I'm gonna order. You spent 1 + 4, 10 days in jail, credit 5, leaving 5 days to serve. I'm waiving all your fines and costs except the $200 restitution. You're going to jail right now.
I have,
You can go for 90 days if you'd like. You're going to
No,
jail
Your
right
Honor.
now. I don't want to argue about it.
I would
There's a
also,
consequence.
nope, I would just like to make a statement.
I don't want to hear it. Thank you. You can go with the officer.
Your Honor. There goes my.
There is a consequence to our actions, and one just landed on you.
I agree to that. Can you grab my belongings?
Judge? Yes?
Right now, I don't have staffing to move both of these, so.
All right, I'm sorry. All right, Mr. Carmona, would you have a seat? Joe, I apologize. That's not very good security policy. I'm doing the best I can, so thank you for your help. I frankly thought we were going to do them by Zoom, but I didn't think about it, calling them off. All right, we're going to return to the matter of Martin Carmona, which is 241951. He's been afforded an opportunity to discuss this case in a private breakout room with his attorney. Ms. Strong, what does your client wish to do?
Thank you, Your Honor. My client is willing to plead no contest to the petition. We are respectfully requesting of Mr. Frazine in the court that Article 11 be removed for possible liability in his next case. We do believe that the Article 1, 3, 5, 8, and 10, a no contest plea to those articles would be grounds for revocation. He understands that. He does understand the recommendation from the probation department and takes responsibility for that. We're just trying to minimize his exposure in his next case, as I don't know the facts of that case.
All right, we're going to take out the admission that you possessed a firearm or a drove, but the other clauses of the petition. You did not violate any law of any criminal unit of government, failed to report, failed to pay fines and costs, failed to test. Do you admit by no contest that you did not comply with those terms of your probation? All right, you do have a right to have a hearing on this, certainly, and your lawyer is here, Casey Strong. At that hearing, it'd have to be established beyond a preponderance that you violated the order. You also can plead no contest or guilty. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow that this admission enter. And with that in mind, Mr. Frazine, what's your recommendation here?
Well, Your Honor, I'm not being aware, but I do understand the no contest plea. But this officer does have reasonable belief that he did violate number 1, and as well as Articles 11. So though we not have an admission on that, I would ask that the court do consider that, especially when you consider how he got on this probation and what it was involved, weapons, etc. So there's a repeat dangerous pattern here in criminal history. He has 2 previous failed probations. And that's why I recommended when you have new charges with weapons, it's very concerning. And he was driving. Police have a reasonable belief to believe that he was driving after speaking with the officer. So refusal to test. He did, I will say, in his defense, the good thing is he did get his anger management class done. So that is a positive. That's a big step, but obviously in the scheme of things, I'm not sure how much we're learning in the future, but hopefully with each time he's involved with criminals, hopefully it takes a little bit more he can apply towards future actions and decisions. But that's why I recommended that when you look at the escalation of sentencing and what was going on with this, that's why I recommended the deferred days plus the remainder of the maximum for this statute, Your Honor.
Ms. Strong, you wish to speak to that?
Yes, Your Honor. Thank you for turning to me. I have spoken with Mr. Carmona. He understands, while I'm not going to speak to his new charges and neither is he understands that in this case, he was given a huge break with the offer from the prosecutor's office and the opportunity to be placed on a term of probation. He understands the consequences of violating his probation and understands that the court is going to impose a punishment. We would ask that the court consider the 183 days in its excess and choose a sentence that is lower than that to allow him to seek employment. He's lost his job due to the incarceration, but he is not minimizing what happened. He's making a no contest admission, but he's not minimizing his role in the failed probation. I would ask the court to consider that as evidence of his position on this. He's willing to take the consequence from the court.
Ms. Canfield, do you have any input?
Your Honor, I think under the circumstances and my reviewing of the case summary of the alleged behavior in the new offense, which indicates that he was stopped for a brake light violation, slow to pull over, had open alcohol in the vehicle. Subsequent to discovering that and conducting a search, they found a loaded firearm under the driver's seat in the new offense. That's what's alleged. I know he's coming up to a PEC and a prelim on that matter. And obviously that's not what he's admitted, but it does pertain to whether he poses a danger to society, and also having failed his probation, which gave him an opportunity to rehabilitate from the exact same behavior. So frankly, I think the full time is warranted, as Mr. Frazing recommended, with a revocation.
Mr. Carmona, I'll give you the last word. Is there anything you want to tell me?
I just want to apologize to you guys both. Like I didn't want to let you guys down, and dealing with this new case, like I just wanted to go home. You know, like I went out with my mom.
Mr. Carmona, nope.
Don't say any more about it.
Sorry.
Yeah, he's throwing his mom under the bus on the new case.
I'm not. I just want to apologize to you guys both. I didn't want to let you guys down, and I really tried my hardest to not let you guys down.
All right, thank you. Well, he had this 9mm Ruger 16 round magazine, a loaded live shell in the chamber. Always makes me nervous. Attempted RNO. He got this. I only gave him 2 days in jail. When I defer jail, it makes it a meaningless gesture, unless sometimes the deferred jail actually comes to roost, which a little bit of it did in the last case. I'm going to revoke your probation. There's no sense to continue it. We'll see what happens with the new case. That gun was forfeited. I'm ordering the original 2 days plus 13 is 15 days. I'm ordering the deferred 180 days, credit 15, leaving 165 days to do. If you are convicted in the other case, it'll be up to that judge whether it's concurrent or not.
Well, what did you do with the fines and costs, Your Honor?
I waived them all.
Waived them all? Thank you, Your Honor.
All right, Mr. Carmona, I guess either me or Judge Pattison will be seeing you in the other case. I'm sorry it came to this, but. All right, thank you. All right, I hope it gets better.
I apologize to you, Dan.
All right, thank you.
Mr. Kuhn is here. Did you talk to him?
Yes, sir.
All right, are we ready to go on him?
You would like a hearing, so.
All right, about Tyler Loy.
He actually has explanations, but he's going to admit the violation.
All right, is he here?
Yeah. A lot of things in the hallway.
All right, yeah, let's bring him in, then we'll talk about Mr. Kuhn. Probation and sometimes is a gift. In the first case, the probation was more to try to get the restitution paid. In the second case, it was just a flat out generous gift, which didn't go so well. Mr. Loy, would you please come forward? This is an old case that goes back to the adage that we have a long memory around here. So go ahead, Mr. Loy, have a seat. This is file 163281 SM, People versus Tyler Lee Loy. That's you, sir?
Yes, sir.
Good afternoon. Mr. Loy is here with his lawyer, John Bush. This is an old paper file. Mr. Loy was placed on probation on a domestic violence charge, and that didn't go very well. He was sentenced in 2017. Then in June of that year, we had a probation violation because he didn't comply with the terms of the probation, and we lost him. I renewed the warrant a couple times. I did a Google search to see where he was. I think it was at Lovell Street in Elkhart. And then he got arrested in September, and we had an arraignment. He pled not guilty, and the matter was set for today. Let's go back to the original probation violation petition. That you failed to report or have any contact since your intake on February 2nd of 2017. You were placed on probation. I don't think we ever saw you again.
That's where there is he would say he came twice or 3 times, but then stopped coming.
All right.
Part of that's going to be his explanation. There was never a probation officer available for him to talk to when he came.
Well, some of this goes back to our friend Gina Wagner,
Yes,
who had health issues. I think he was here in the hallway a time or two. I'm not sure what happened. At any rate, then we just lost track of him. So is that true, Mr. Loy? You're willing to acknowledge that you did not comply with the terms of your probation?
Yes, sir.
All right. Anybody threaten you to get you to make that admission?
No,
Or promise you anything?
no.
You understand you could have a hearing on this where it'd have to be established beyond preponderance that you violated the terms of your probation. You understand?
Yeah.
All right. I ordered 14 days jail and deferred 10. You had 4 days jail credit. I lifted the no contact provision, and you were ordered to do the anger management class and do some drug testing and alcohol testing. You said I would discharge at the end of 6 months. I don't think any of that was ever done. None of the classes, none of the testing, none of the payment. And Daniel's recommendation today is that we impose the 10 days of jail. We'll see about that. I did let you out of jail when I did your arraignment. I gave you a PR bond.
I do believe there's been $315 paid at some point.
All right.
I checked it this morning. Yeah.
Mr. Bush, what would you like me to know?
This obviously was not a successful probation. And I, to the best of my knowledge, I wasn't involved in this case at the beginning, and certainly I don't have an existing file. Mr. Lloyd shares with me that he came 3 times for probation. Every time he was there to talk to somebody, the probation officer wasn't there. He paid money the first 2 times. 3rd time he wanted the court, no, he actually rode his bicycle here. It was a 3-hour ride one way back and forth to try and report. He shares with me at that point, he left a message, or is there any way we could do this by remote or do it in Indiana? And he never heard back. I think at that point he moved, so probably the court lost track of him. But interesting circumstances is he's currently a full-time caregiver 24/7 for the victim in this case, who has not been in good health. He's actually compensated by the state of Indiana as her caregiver. She's in bad health. She's currently in the hospital, as a matter of fact, not doing well at all with long-term medical issues. Not his fault or whatever.
Well, that's why I let him out. The irony is that the lady he was accused of assaulting so many years ago, he's now the primary and sole caregiver for.
And in support of that, the victim's mother's in the courtroom today, so supporting my client.
All right. Mr. Lloyd, what happened? You just gave up and decided to?
No, what happened, Your Honor, is the first 3 times that I came, I was struggling to get here. And when I had talked to the lady at the desk, on my 3rd meeting, I had asked her, could I get it switched to Indiana, or could I get some kind of information on how to get here? Because I was so afraid to fail to get here, because then that would have been a violation. And so she told me to wait on a phone call, or we would send a letter in the mail. And then after, I want to say so many months went by, I can't remember exactly how many months, but so many months had went by. That's when we started looking into getting a new house, because we were moving. I was with my grandmother and she was with her grandmother, because I lived in Indiana, she was in Michigan. So we were trying to get a house together. And so we had ended up buying a house that her grandmother owned in Indiana. So once I bought that house, we just started moving there and fixing it up. And that was right like a year before COVID hit. And then when COVID hit, that was it. The Lowell Street address was from when I was 18. That's why I didn't get that mail. I'm very sorry about that. That's all it is. I just been taking care of her since I got released. And then around 2021, she started getting super bad to where she couldn't even walk anymore. And so it's just 24/7, 7 days a week. I take care of her, the bathroom, everything. I feed her by hand. So that's how it is. I've just been at home 24/7, taking care of her.
She has Guillain-Barré?
It's called Guillain-Barré syndrome. Before that, she had cirrhosis. So she had lost her legs. She would gain them back. And now in about 2020, 2021, they finally diagnosed her with Guillain-Barré syndrome, to where her nervous system attacks her immune system. So where any kind of physical touch hurts, and she can't grab things because it'll hurt her hands. She can't stand because it hurts her feet. If I was to clean her up for the bathroom, that hurts. So that's how it's been since.
All right. Ms. Camfield, you had an opportunity to confer with the complainant's mother. You have a position here.
Prior to speaking to her, my recommendation would have been that he needed to serve his maximum time. I'm hearing a lot of excuses. I moved, I tried, but if you don't update the court with your proper address, and you know that you've been on probation for 8 years now, before you finally appear before the court, that's troublesome to me. And interestingly, I'm very, very sorry. I do have confirmation that Amanda is in the hospital. She is very, very ill. And unfortunately, it's not a good prognosis. But at this point, she is in the hospital. She has a caretaker, but her mother indicates that the defendant assists her as well. I don't know. I mean, my recommendation was going to be the max jail with credit for whatever he served. He just has ignored the court for 8 years. And whether you tried to get it transferred or whatnot, and now your excuse is I didn't get the mail because I moved, it's your responsibility to update your file, the court, and your probation agent with your new address. It's probable that it could have been transferred at some point and things could have been completed. But the goal here to rehabilitate him from this behavior, it didn't occur. And I'm very sorry about Amanda's condition, but I'm reading the original report. She was punched multiple times in the face and he started to strangle her. And the officer noted swelling and redness to her face and a split lip when he took her original report. And I mean, it's certainly a very tough position to have him needed by the family, one of whom he originally injured to be on probation in the first place. I really think that the jail is deserved, but there is an extenuating circumstance that he's apparently needed, not for Amanda, but by her mother at this point, because Amanda's being cared for by the medical staff.
Sometimes there's not a good answer to the question. The question is, what do I do with him? And there's not a good answer. Way back when, at the time of the victim impact statement, she was minimizing, and it was certainly in his camp. She wanted it to be over with. She wanted to get her family back together. She minimized the nature of her injuries, but she wrote me a long, thoughtful letter. And she wanted him back. So I don't know whether I rehabilitated him or not. I guess part of his rehabilitation is he's been his 24/7 caregiver. Difficult, hardcore caregiving. So I'm going to revoke the probation. He did pay $325, which I think we took out of a bond, and it's no deferral. He's going to lose the deferral. So after all these years, it's going to show up on your record. I'm going to order 5 days credit, 5 days. The 4 you did at the front end and the other day you did here. When you were here in August, I believe, or early September, she was not in the hospital yet. So you've been her caregiver for several years. You've been gone for 9 years, which, as I said, I have a long memory. I've reviewed this file several times over the years, but I'm just gonna let it go. She needs you. Your wife's mother needs you. You haven't gotten in any more trouble. And you got picked up by accident coming back into Michigan. And this will show on your record, but I'm going to give you credit for the day that you served. And it would be a punishment to your wife and her mother if I were to put you back in jail and just make their circumstance even worse. So you're free to go.
Thank you, Your Honor.
Thank you, Judge.
We're actually 4 for 4 here today. You're free to go.
Thank you, sir.
Mr. Kuhn, would you come up and have a seat?
Yeah.
Good afternoon, sir. Are you Ashton James Coon?
Yes, sir, Mr. Honor.
And we've met, but I need to identify you for the record. Let's go back to square one. This is file 241568 SD. You got pulled over on August 21st of 2024 at about 11 o'clock at night. M60 and Hass Road outside of Mecca. You were charged with operating while intoxicated and failing to stop in an assured clear distance. Your blood alcohol was 0.15. Plea offer was related to impaired driving. You pled to impaired driving and the matter was set for sentencing. Find the judgment. You were given what we call a timeout probation. You got 12 months probation, which could have been completed in 6 months, 2 days jail, credit 2 days. Or did you do the victim impact panel? No drugs, no alcohol, and substance abuse treatment if indicated. Daniel Frazine was appointed to handle this matter. He's filed a probation violation petition alleging that you violated your probation. 1, you failed to not violate any criminal law of any unit of government. 2, you failed to pay your fines and costs. 3, you failed to abstain from the use of alcohol and drugs or test on demand. And 4, you failed to participate in treatment as directed. I think you were here on August 13th for your arraignment. It took that long to get this set. Yes, it did. You have a new drinking driving charge from June of 2025 in Three Rivers. And that in part is the basis for this violation. Mr. Frazine's report shows that we had some struggles getting our testing done and our treatment done. And then you got this new arrest. As I mentioned earlier, it's always an issue regarding a admission and a probation violation when the other case is pending. Mr. George, you represent him on the new case as well?
I don't know that, I checked the court's website today. I don't know that it's been authorized yet, has it?
Yes.
Has it? Has he been arraigned on that yet?
I'm not showing a case number yet, Your Honor, so it may be that he's not arraigned yet. It was authorized by my office on August 26th.
Oh, my gosh. Could we find Ashton Coon's new operating while intoxicated ticket? I think he also got a note. What was the date of the offense in that one, Daniel? Do you know?
I have 6/18.
That's what I thought. He got a no proof insurance on April. All right. All right. So let's further discuss this, Mr. Coon. Daniel, his recommendation to the court was revoke your probation and impose 4 days of jail. We haven't been doing very well regarding this probation. And then if we need to do something, and if you do get convicted in the new case, we'll deal with that. I don't even know if it would even be a sobriety court case or what. Mr. George, what does your client wish to do?
I've gone over the petition with my client, and at this point, he wants to have a hearing on the petition.
All right. The new charge contains a couple of the bond violation conditions. One, not violate any law of any unit of government. Two, don't drink any alcohol. According to the information that Daniel had, you got arrested on June 18th doing donuts in your vehicle. And you had a 0.167 blood alcohol level. So that violates, don't violate any law of any unit of government and don't drink any alcohol. The problem is that case is still pending. And you did come in later and advise Daniel of the arrest. And he tried to get you set up for testing at the day reporting center. And then I'm still hoping someone is trying to find that new citation on Ashton Kuhn. And I hope it hasn't been in our system since August. I will be greatly embarrassed.
Want me to run over there and see if they're-
I think hopefully they're working on it.
Your Honor, in looking at the misdemeanor complaint and warrant packet prepared by my office, it was charged as an operating while intoxicated second offense.
I just found the complaint was just brought to me today by the officer, so I'll get it in the system.
Okay,
And an open container. In a
so we didn't have it till August. We just got it today. So I'm not sure what happened. All right, she's gonna open it and bring it out.
Your Honor, I think it's sometimes just the cycle of the court officers for the departments when they can get here.
To sign it.
Mhm.
All right. Mr. Frazan, would you please raise your right hand? Mr. Kuhn, would you raise yours?
Yes, sir.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
In Jesus' name, amen.
All right. Absent the new charge, let's talk about what your other basis for filing this probation violation petition was.
Your Honor, may I inquire?
Yes.
Thank you. Mr. Frazine, are you a probation agent with the St. Joseph County District Court?
I am.
And did you have Ashton Kuhn on your probation caseload?
I did.
When was he placed on probation?
10/28/2024.
Did you read to him the terms and conditions of probation?
I did.
Did he indicate he understood those?
He did.
Did he have any questions about any of those terms?
He may have, I would have answered them at the time.
All right. Was one of those Article 1 failing or not violating any criminal law of any unit of government?
Yes.
Was Mr. Kuhn able to comply with that article?
No.
What did he do that violated that article?
He got another offense charged with him for a drunk driving, and his chemical breath test on that, according to the report, was a 167 and a 155, and he had open bottle in the vehicle.
How did you obtain that information?
He actually came in and told me before I found out from the police officers that he was drinking and driving. He was doing something really stupid. Apologized for it. I had a very frank conversation with him on 6/24. I let him know how another drug driving offense would affect him. It could possibly end up with a 3 to 5 year suspension. He became extremely agitated, and I walked out of our conversation and left the basement floor and went. And I basically didn't hear from him again until he called on 7/24, but I was out in the office to take a phone call.
All right. So it's my understanding then that Mr. Kuhn, the defendant, admitted drinking and admitted driving with alcohol in his system.
That is correct.
And did you have an Article 5 that he needed to pay all of the fines and costs as ordered by the court?
That is correct. And as of this morning, when I checked it, there was 0 paid.
All right. As Article 8 and 10, failing to abstain from the, or excuse me, your allegation is that he failed to abstain from the use of alcohol and drugs or submit to a test. What evidence do you have that he violated those?
Well, the police report for the new charge is admission to me, and I did attempt to put him on a 1 time a week testing at the day reporting center. However, on August 15th, He went in to meet with them to do their intake with them and sign the appropriate paperwork. He told him he would not sign it without his attorney present and never returned and never called me.
So you wanted the defendant on weekly testing, but he failed to comply with initiating that service?
That is correct.
In Article 9, does that say that you are to participate in treatment as recommended?
Yes, he was to get a substance abuse assessment, and to my knowledge, he hasn't had that. And he basically, most of our conversations was he didn't think he needed any help and he didn't want to participate.
Are you gonna arraign him on it? Okay.
All right. So I'm sorry, you wanted him to do a substance abuse assessment and any recommended treatment, and he told you he didn't need it and wasn't going to undergo it?
Yes, I knew there was obviously a possible alcohol issue here, but I also wanted him to get that even more so for some suspected mental health issues that I thought were underlying issues as well.
Thank you. As a defendant, I know it's not within here about whether he was reporting regularly, but did he keep in communication?
He was reporting regularly up until he got the drunk driving, and really, he could get easily angered when I approached him trying to help him with getting into services and stuff. He said other people had tried to suggest he get services. He didn't want any help. He didn't need help. He didn't like meds. But he had called and reported. I just was having a hard time getting him into that treatment, which was the next big pivotal for me with him. And then once he got the drunk driving, we had that very frank conversation how sobriety court might be his only avenue for a license for the next 3 to 5 years, and going over what that might entail. He got very upset, in my opinion, was because it was going to be a very laid out, structured, treatment oriented program. And that's what I think happened. And that's why I believe he walked out of our conversation and left.
If I may ask you, Mr. Frazine, in addition to the defendant's statements and admissions to drinking and driving, did you have any other evidence regarding that particular alleged violation?
Of the drinking?
Correct.
Other than the police report and his admission to me about that drinking on that offense, no.
Did you reach out then to the law enforcement agency that arrested him?
I got the police report. I believe that the officer called me on this, but I don't have my notes in front of me, so I can't say definitively, but I did get the police report and review that. And I had several conversations with your officers along the way. They told me that it was the department that was holding up the charging. That's why it took so long, but what that was and why I did not know.
All right. And with respect to the blood alcohol of 0.167, did you obtain that out of the police report?
That is correct.
Thank you. Nothing further, Your Honor.
Mr. George, do you have any questions?
I do. Dan, when was Ashton placed on probation?
10/28/24.
Okay, and you do an initial intake with him, is that right?
That is correct.
And you go over what the terms of the probation are. Is that true?
That is correct.
So at that time, he had, how much was assessed by the court in fines and costs?
That is correct.
How much was assessed by the court in fines and costs?
Total of 1,000. If he stayed for the whole time, which I tell them, if you do well, you'll be able to half that. So, but the whole sum was $1,442.
Okay, and it's your testimony that he hasn't paid anything to this date, is that right?
As of this morning for the computer, yes.
When you do that initial intake with him, do you go over a payment plan, or what do you advise a probation or when they come in for that?
I let them know that, back in the old days, you couldn't get off probation until that was paid in full. But now, as long as you show a concerted effort making regular payments, and typically we want at least 3 consecutive monthly payments, we can set up a payment plan, and you can actually get discharged as long as you complete the other tenets of the or terms of the probation, and you don't violate or doing it would cause a revocation or something like that.
Okay. And throughout the course of the probation, was employment an issue?
He mostly had a job. I off the top of my head, I don't have that here. I do know I requested a pay stub from him back in March of this year. I don't know if I ever got it.
Well, didn't he work at Jones Farm?
I know he worked at a couple different places, but I can't remember much more about that. I do know that as of the last few months, he was not working,
Okay.
according to what he told me.
So you, at least at the beginning of the probation, your testimony is that you believe that he did have an ability.
I do.
Okay. And I note on your report that you indicate that he had missed a substance abuse assessment and prime for life. Is that right?
For the prime for life, I got in, I think, the end of August. I did get a cert for that finally.
Okay. Was that from Mr. Kuhn or was that from Pivotal?
I believe that was from Mark Olson from Pivotal.
Okay. So has there been a release?
He may have sent me a copy as well. Sometimes they both send it to me, but I can't remember.
Okay. So has there been a release that's been signed to get information from Pivotal, or was that just provided to you?
That was just emailed me, the completion certificate.
Was the prime for life something that was specifically ordered as part of the judgment of sentence?
I don't have that on me. It is a very standard order, but I don't have that. I don't have a copy of the judgment in front of me, so I don't know for sure, but we are allowed to add that as we see needed to.
Okay. And the reason I ask is, was that something that was ordered as the judgment, or was that something that was recommended after a substance abuse assessment?
It definitely wasn't after the substance abuse assessment, because I went through, there is no substance abuse assessment on file or in the notes.
Okay. So on file means that you have access to the Pivotal resources that.
And I would have either spoken to a therapist or they would have emailed me the copy of this.
So you've been able to confirm through Pivotal that he has not completed a substance abuse assessment?
As much as I can. Sometimes they will tell me if there's no RI, they will say I can't confirm or deny at this time, and I don't remember what the conversation was, but I don't have one. And I do have notes that I spoke to him and reminded him several times throughout the probation that I need that.
Okay. Do you know that if he's engaged in any type of mental health treatment at this point?
At this point, I'm unaware of.
Okay. Is it the probationer's responsibility to pay for a test when they go in to test?
Unless they're working with Pivotal. And that's why I explain that and suggest heavily that they can make it work with Pivotal because they have grant money. And up until 3 weeks ago, they had enough money to pay for most of it. But the last month in September is quite often run out of money and they have to pay for that month. And then they get renewed in October. So
was Mr. Kuhn ever not able to test? From your knowledge, was he ever not able to test because he couldn't pay for the test?
I do believe that there are a couple issues in the early on that said that he had no money to test. Okay. And again, on 3/5/25, defendant was reminded about getting into service for Pivotal. He also said he had no money to test. So hence I would have said, well, let's get around that. Here's how we can get around that.
Okay. Do you know how much it would be to test if somebody wasn't engaged at that time?
Back at that time, I can't remember if it was 35 or 40, but it's now 46. Okay. I've had a couple increases in this.
And do you know what the documentation is that DRC wants an individual to sign that Mr. Kuhn had an issue with?
No, but I know it's a similar sort of intake process like we would do.
Okay.
Just saying it, this is how it works. We will call you. You will. We'll call you if we don't get hold of you. We'll leave a message up to call us back, and you have to test that day, and you'll be responsible for fines if it's not covered.
And that happened in August of this year that you wanted to get him into.
Well, I've been trying for a little while, but when he actually showed up, my email from DRC is dated 8/15
of this year.
Of this year.
Okay. And on your report, it ends with June 26th. Is that right? Is the last kind of entry on the report and the status report that you provided as
part of the
yes. Violation?
Yes. I did have a conversation, I think 7/9 and 7/24. I have that he called, but I was out of the office.
Okay.
So I really didn't speak with him then. But so 7/9 would have been the last conversation I would have had with him.
So as Ms. Canfield has said, he has generally reported as
up until
that right?
This offense, yes. Things went south after that.
Things went south in June?
Yeah, after a conversation on June 24th.
Okay. But then he reached out to you a couple times in July, but you weren't there. Is that right?
One time I was, and the other time I was not.
Okay. And then was there contact? I know you had the contact in August as it related to the documents at DRC. Is that right?
Yes, and there was a couple times I tried to call and leave messages, or his phone was shut off. and or his phone was shut off.
Did his number change at some point?
I can only go by what they give me, so I don't know if it changed or if it's, a lot of times people, it'll not go through because they haven't paid their minutes.
Okay. I don't have anything additional. Thank you, Your Honor.
All right. Mr. Kuhn, you wanted to have a hearing on this. I'm not exactly clear why, but you're under oath. Mr. George, does your client wish to speak to me?
Based on Article 1 and the allegations in there, I would advise my client not to testify at this hearing.
All right. You have a right to speak. You also have a right not to speak, but anything you say could implicate you in your pending case. So with that in mind, do you wish to remain silent on this subject?
No.
You wish to tell me?
Yes, Your Honor.
All right. Against your lawyer's advice, do you wish to tell me what you want me to know?
Yes.
All right. What do you want me to know?
Speech here. No disrespect to Dan or anybody in this courtroom. I did everything that you have asked me the last time I came in this room. The only thing in pride that I had not done was the payment. I told you I was homeless and stressed out. I am under emotional stress with money and financial help. I do not have a home, been on the streets for a year. That's not the point, but forgive me for my wording, it's not correct. Like mean accurate and precise. I have the strength to say this because I'm honoring me and my family's name and God's name. The last time we had this courtroom, and Dan actually pulled me aside. He said before this, he said, I need you to come to the basement with me. Next thing you know, I'm all soft and going out and ready for Mr. Tim and getting my paperwork from Mr. Tim. Next thing you know, I see Mr. Dan talking to my grandfather, and it looked pretty sketchy. I walked in back prior into the room where there's a TV and a camera where I'm not advised if it's on or not. But this man sabotaged my name, disrespecting me, said I'm not ever going to be successful, never going to be this, never be that. I don't know how to precise wording to remember it because I try not to because it stresses me out. And
what is this at the time of your original plea or more recently when you came?
That was the last court case we've had together.
All right, when I did your arraignment.
Yes, sir.
All right.
And just to get off my chest, he pulled me on the other side, kind of stood over me, kind of got a little bit of his when he was talking to me, and I stood there and stood firm, and I'm trying to let it go right now because it's not irritating, but why I'm thinking about it is because this man was saying, "Are you gonna get mad? Are you gonna get mad?" And it frustrates me. I'm emotional. I'm stressed out. I looked up to this man. I'm not gonna lie. I looked up to this man. I talked to this man for 5 hours about God. The very first time I've ever talked to this man. I talk to him every time. He's always on vacation. Always say, "How you doing?" And I took it to a personal offense. When the last time I talked to him, I looked into him. He was like, "Who are you? What's your name?" And I took it personal, I took it personal saying, "I thought you knew me, Mr. Dan." And he said, I don't know you. And he kind of looked at me like scum.
Well, he didn't know this version. None of this rises to a defense. Let's back up. You rear-ended a guy on M60 when you were
12
drunk.
months prior, 1 year.
Very near to where more than one fatal accident, very near where you hit this guy. There was another fatal accident within maybe a half a mile of there.
Yes, sir.
Stop. So that's serious stuff. You almost killed somebody and yourself. And there was uncertainty about whether you were trying to kill yourself. Your girlfriend and her mother had a concern that what you were doing was trying to commit suicide. We had a young girl this week. She wanted to commit suicide. She pulled out in front of a semi and seriously injured the semi driver. So he's physically debilitated, but she didn't die. So she's charged with reckless driving causing a serious injury, which is a 5-year felony. So let's assume you were just drunk and not trying to kill yourself, that you passed out or fell asleep and you rear-ended this guy. That merits court supervision. Dan and I had several discussions about you. You are young. You are a man of faith. You were repentant about what happened, and we were gonna try to do this probation. I think Dan was frustrated with you. And then this stuff happens. You're driving like a fool in the parking lot of the Old Three Rivers Hospital, drunk, doing donuts. You think no one's gonna notice that? You're 0.18. I'm embarrassed that it took from June 11th June 17th to now. You went to jail. This is an old Dave Marvin holdover. They wanted a complaint. You went to jail, you sobered up, they let you go, and you didn't get an arraignment date. So some time later, the officer submits it to the prosecutor's office. There's no blood test. They're not waiting for anything. You took a breath test that night. If this had been an OUL first offense, it would have just been dealt with. Anyway, I don't like this process. Ms. Davis inherited it. This isn't the way I did it. At any rate, so you get out. A week later, you did tell Dan. At some point, it gets into the prosecutor's office, and they authorize it on August 26th. So it sits there for a while until the officer came and swore to it today. So we just got the complaint today. So I'm going to arraign you on your new charge here in a minute. But so Daniel discussed with you sobriety court. And he told you the cold hard fact that if you get 2 convictions of drunk driving, your driver's privileges are going to be revoked, meaning no driving for at least 5 years until you get the Secretary of State to reinstate your license. The only way to get your license back is to go through a sobriety court program. I don't think you're ready for a sobriety court program. I think there's some underlying mental health and depression issues. And maybe I'd be depressed too if I was homeless, didn't have where to go, and had relationship problems and no job. But the answer to that problem isn't getting drunk and doing donuts in the parking lot of the old hospital. So right now we're just dealing with a probation violation issue. And then in a minute, I will arraign you on the new case. Is there anything else you want to tell me?
So prior with everything that you said that I have not done, because you have not known, I have done everything that was asked before I came into court and before then prior. Though I do not know the officer's name directly, but I have been here in the courthouse, done the first thing that was set up to go, serve my 3 days in jail.
Yes.
And then I have done beyond the point, not for the satisfaction of the systematic government, but for God and family and friends. I have stood tall, and I'm a sober man. I'm a clean man. I'm an honorable man. I've been through trials and struggles. That's none of the business. It's truth of my testimony. I'm very clean. I'm just emotional distress only on financial stress, for I am homeless, and I'm here to try to take care of my dog.
Your grandpa brings you here, and I always appreciate that. Who lives on Hutchinson Road?
So my mother and my father. My dog's in the back seat of my truck that we live in right now, with water and clean. I do not live with my family as a normal man and a humble man. I don't want to be around family because I'm stressed out and don't want to lean on somebody that I can't lean on, because may someone not know the strength of it. So I rather keep to myself humble.
What's your status with the girlfriend?
Status with girlfriend, unknown.
Are you not with her now?
I cannot say for that for right now, for that's personal relationships that I'm working on with God.
All right. When did you last work at the Jones farm?
Joe's farm. I've worked there. Great company. I've worked there for summer. I'm not very known of months. I don't keep track of this. No, I don't care for it. I worked there, and after that, I was out on the streets. I lived in my suburban.
All right, but this was summer we just had. When did you last work somewhere for pay?
Bayer, actually, the hat that I have is on the seat back there. I've worked for Bayer. I filed into unemployment.
What is Bayer?
Bayer is that place we talked about last time, that big facility on the right side. It's a world company.
Oh, Bayer.
Yes, sir.
All right, and what did you do there?
Right there was test plants.
All right, and when did you last work there?
I know, like I said, I do not keep track of dates, but I don't believe in that.
This is now October. We just went through September. Did you work anywhere in the month of September?
I can't recall because I don't remember dates because I just don't believe in it.
How'd you like it? They put you in jail and they forgot what day it was, and you got 4 days, and 84 days later they let you out. I didn't think those questions were that hard, but you're living in your truck. Where do you get money?
Where I get money?
Yeah.
Family, as much as I can. I ask for the bare minimum. I do not have the confidence to ask somebody for money, but that's not my place.
Well, the fact that you don't have a job and the fact that you don't have any money are related. If you had a job, you'd have some money. But, all right, I find that the defendant has, by a preponderance, violated the terms of his probation. He acknowledged that he drank and drove and got arrested. And that was the #1 condition of the probation. That's not a corpus delicti issue because Mr. Friesine has independent evidence that the defendant drove from the police. I don't know what you were doing, and I don't want to talk about that case yet. But you're struggling all right, and part of your struggle is a mental health struggle. And I sure would like to get some addressing of that. I find that the defendant failed to pay any fines and costs. However, he doesn't have any money, but he didn't pay any money. He failed to abstain from the use of drugs and alcohol. Is a violation by his own admission. He failed to participate in treatment, although he tried to do some of the things we ask him to do. So I'm going to revoke this probation, Mr. Kuhn. Where is your dog right now?
In my truck.
Can somebody take care of your dog?
No.
I'm not lock your dog in the truck for 4 days. You're going to jail for 4 days.
Grandfather, can you take her?
Not me.
Call mother. You better take care of Raven.
I was supposed to be leaving yesterday.
Well, just call mother. That's my dog.
All right, we'll make sure your dog is cared for.
Can I speak?
Yeah.
By any means, is this to hire up to the Supreme Court of the breaking of the constitutional rights of freedom of speech and the freedom of my name of protecting and sabotaging. And as the foremost, that is everything recorded through everything that's there. It's justified in my actions and my honor and the way I speak. I am not irritable nor I'm angry. I'm disappointed and stressed out, emotional, financially insecure. I'm protected by the constitutional rights, and I was sabotaging my name. I'm sabotaging my emotional distress, which is a lawsuit, and it's forbidden in the Constitution and in the court systematical.
Well, I agree with you, Mr. Kuhn.
Yes,
you are
sir.
sabotaging your name and sabotaging your name, your reputation.
Negative. Forgive me, Your Honor, I have freedom of speech that I can stand in the honor of God, for God is above all, which is a freedom of my religion, which I'm stood by and protected by the Constitution of my rights. This is a breaking of constitutional rights back and
I
forth.
don't want to go down the rabbit hole. I think we've got some significant mental health issues here. I'm going to order, the probation is revoked. I'm going to waive your fines and costs. Daniel's recommendation was 4 days jail, and I think it's appropriate. You crashed into some guy and nearly killed him. You did a poor job on your probation. You got arrested for very foolish behavior in June. I do regret it took from June to October to get the thing to arraign you. But we're going to address that in a minute. I'm going to get you a lawyer on that.
Your Honor,
yes,
we haven't run this before, but his grandfather said the dog doesn't like him. I'm guessing he's afraid of it and or poses a risk to him, so he doesn't want to help with that, and which I understand.
What kind of dog?
We might have to get that pound or the.
All right, or either I have to let him turn himself in.
I was thinking maybe we just get the keys so they don't have to like break the window to get the dog.
My keys are unlocked, and you can call PD.
What kind of dog is it?
She's a black lab German shepherd, the sweetest girl. She only barks, but she don't bite.
Well,
you can call PD, 3 Rivers. They'll take care of her, please, for the love of God, because they're the greatest.
Well, I'm not gonna leave your dog locked in the car outside.
Just one.
For 4 days. Well, let's set this aside for a minute. I'm going to arraign you on your new arrest. You got arrested in 3 Rivers on June 17th for operating while intoxicated in the parking lot of the old 3 Rivers Hospital. It's alleged that that is a second or subsequent offense because you have this conviction in file 25 or 241568. Making that a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. And it requires that your license be revoked. Mr. George is here to make sure we're complying with your rights, but he's not your attorney in this case. I'll show that you plead not guilty. I'm going to appoint an attorney. I'm gonna set an attorney pretrial for November 7th, 2025 at 8:30. You've already been arrested. I'm gonna set a $500 PR bond. So that's the new case, and I apologize that it took so long to get from there to here. But the good news is you didn't get arrested out on the street. You happened to be here for court, and I took care of the arraignment. So let's go back to the other case. I have found that you violated your probation. And as of this minute, you're still on the probation. I'm going to order 4 days jail. We're going to have to schedule it. I don't want your dog to be left out here alone. You're going to have to make arrangements to board your dog. I'm going to start the jail at 7 o'clock on Friday night. not doing very well by you. What I intended to do was put you in jail right now, call our mental health liaison to meet with you and see what's going on. But I'm gonna have another crack at you in the context of the new case. Your probation is continued until further notice of the court. Because I want no alcohol conditions, and I'm not making them part of the bond, I'm making it part of this. Probation is continued. You're sentenced to 4 days, credit 0, leaving 4 days to be scheduled as a weekend. Starting at 7 p.m. this Friday night, which would be October 3rd. Can you find someplace to board your dog by Friday night?
Yes, sir.
7 p.m. As I said earlier, sometimes there's no good answer to a problem. Mr. Kuhn, this is not meant to be an insult or demeaning, but I think you need some mental health treatment. We tried to get some. You're very stressed. You're living in your truck. You're not working. The person primarily responsible for your well-being is you. This isn't somebody visited this on you. You're making very poor life choices. I think some of it has to do with the status of your mental health. So it isn't like somebody did this to you. You're doing it to yourself. You've estranged yourself from your family. You can't keep a job. That's not healthy behavior to be living in a truck with your dog. It's about to get real cold. Your dog deserves better than that. So I need to get in here and figure out what's going on. The other issue is whether you'll ever have a driver's license or not. I don't think in your current state you're ready to do sobriety court. Friday, October 3rd, 2025 at 7 p.m. Report for 4 days jail. Now, if you don't report, it violates your probation. I could just give you the rest of the 93 days. As soon as we do this 4 days and get to the other thing, I'm inclined to revoke his probation. I'm not going to charge any additional money. I'm not even going to make you report. I just want you to have a no alcohol condition. And at some point, if I can get the opportunity, I'm going to order some mental health evaluation. If it weren't for your dog, you'd go right now. That's not your grandfather's obligation to care for your dog. And I don't want the dog to go to the pound, the dog jail, which we've done more than a few times. There was one guy who, I won't say his name, but he got arrested often. And his dog was so comfortable, they just opened the door and the dog would go get in the patrol car. He'd go to jail and the dog would go to the pound, and then he'd get out of jail and go get his dog. I think the dog had more sense than he did, but I think he and the dog may have both passed. All right, you got it. You got to show up for jail at 7 o'clock Friday night. You got 4 days to do. You're still on probation. You got a new case where I've appointed a lawyer for you. You're going to need to go out and get the paperwork for that. The court date on